Regular pension.
My lord, may I have your lordship's leave to, my lord, mention a matter, my lord, on behalf of the NIA, my lord, on your lordship's, my lord, by your lordship's order dated, my lord, 9th June 2026, 5, my lord. You are pleased to submit the report. Last chance was given to us. Our report is ready, my lord. It was to file, my lord, on 30th June. So, my lord, may we file the report before your lordship's, my lord, because it was last chance. Matter is to appear on 9th July, but report was to, my lord, to be filed, my lord, on 30th June, my lord. We have received the report, my lord. We can file subject to your lordship's, my lord. Leave, my lord. Report is otherwise ready, my lord. Because if we do not file, my lord, there will be violation of your lordship's order. Report is otherwise ready, my lord. We have in a seal cover. Report is there, my lord. We can file it, and it may appear or on 9th, my lord. Whatever your lordship's.
Keep it with you. Remind us that you
my lord.
mentioned.
My lord.
My lord,
Yes.
an application for stay.
Upon notice.
Yes,
Referring upon notice.
well, I have given the notice and the due date was on 26th. I have served upon the state. The matter will appear on 26th. And I will again inform, my lord. I will
26 আসার কথা? Your returnable date was given
26.
26.
Yes.
Yes. ব্যাপার ওটা ডিপার্টমেন্ট থেকে সাথে সাথে পাঠায় না?
We have filed the application. We have served upon the other sites.
Are
And
you
my lord,
mentioning upon notice?
yes, your lordship.
দিয়ে দেবে শুক্রবার দিন। This is in connection with appellate side matter or original side matter?
Appellate site matter
All right, it will appear on that date.
on Friday, my lord. Both of.
Intimate them. Yes.
My lord,
Much problem.
item number 3, my lord, the speed post has not gone to the.
Just a moment, Mr. Sawan. Let us go item. Yes.
Lordship, I am for the petition appellant. Upon written instruction, Your Lordship, I want to take withdrawal of the matter.
For the respondent, your lordship.
The written instruction.
Appearing for the appellant petitioner prays for leave to withdraw the appeal on the basis of the instruction received by him on 27th June 2025.
I am for the petitioner respondent.
No, I am for the appellant.
I appear for the state respondents in this matter.
তোমরা দিতে আসো। ঠিক আছে।
ওটা কোনো bill? এটা কি news?
Yes,
Well, already in compliance with the order of the Honorable Single Judge, the project officer 2 already passed an order for removal against the appellant. And the
But the
appellant
appellant-
already,
are you there?
Yes, my lord, yesterday I have been briefed. My lord, if you would also kindly give me only 2 days time.
well, I have a document to show that the appellant already received an compensation for
Kindly try
to
to
vacate the
highlight
premises from the government.
whether there is any,
There were
whether there
certain
is
defects
any
pointed
scope
out.
for interference.
There were certain defects pointed out by the department.
Oh,
And it is also out of time. So there is no appeal in the eye of law. If that has been implemented.
yes.
There is a delay of 233 days.
So he has to take steps for removal of the defects.
Already
My
filed.
lord,
That
দাঁড়া।
And there is a
Since
and there is a direction for removal of the appellant from the place because they constructed the
So very
structure.
good, sir. We have not interfered.
Yes.
There is no appeal on record.
Yes.
So whatever has
Yes,
been
yes,
done
yes,
has
yes.
been done. Whenever it is taken up, you will
Absolutely,
point it
absolutely.
out to us.
the 230 days delay, that has to be, if the condition of delay is, then the appeal will be registered. Only after condition of delay.
my lord, the delay continuation application has been filed, being can
Yes,
Can do.
233 days delay, I find.
233 days delay.
Can too. Have you given copies to them?
কপি দেওয়া হয়েছে? কপি দেওয়া হয়েছে তো?
No, no, no. No copy has been served upon us.
যাবো। কপি দাওনি?
Next
And
Thursday.
there is
Final?
the executive magistrate is directed to immediately remove the
It
appellant.
has been served. This is the evidence service.
All right, you check up the order of the
Lordship.
register. And if it has been served, it is served. We take it up on next Thursday.
My lord, day after tomorrow, kindly.
Next Thursday we are taking.
Yes,
Next
yes,
Thursday,
yes.
okay. So the evidence service will be.
Keep it with you. Yes, next.
Obliged, madam, grateful.
Record to
হ্যাঁ।
record to back.
Thursday মানে এই day after tomorrow.
Day after 3rd July.
Record to দেখতে।
তখন মাথাটা। Serve in the meantime upon the state
Lordship.
council as well as everybody.
Yes, yes, yes.
And check up the-
Yes, yes.
Check up what are the other defects.
Lordship.
Yes.
Obliged.
Obliged to you.
Lordship, I'm led by my learned senior Lordship, I'm led by my learned senior, Mr. Surajit Samanto. He just came before Lordship a while back. The private respondent hasn't been served, Lordship, due to Rath Yatra. In the meantime, we had served copy on 26, but the thing has not, it has not
What do
received.
you want, madam?
Lordship, just day after tomorrow, if this could be placed, once they receive it, because it's still in transit, as per the track reports.
Next Monday,
I'm grateful.
on Tuesday. Next Monday is combined list. It will be on Tuesday.
Madam.
Yes, madam. Tell him, tell her.
Tuesday,
বলে দাও, next Tuesday.
I am for the appellant. My lord, item number 4, I am appearing. My lord, I have some difficulty, your lordship. Not happening one day.
Let us see what is the matter. You are the state, na? You are the state. Any private respondent?
My lord, the contemners, though they are the my lord, state respondents, but they are the contemners, my lord. The original contempt applications, my lord. My lord, in this appeal, my lord, I have challenged the my lord impugned order dated 26th of July 2024, which is at page 125. My lord, starts from 1 to 5 of my CAN application. The relevant portion is at page my lord 130.
Have challenged this order.
Yes, my lord.
This order of 26 July.
My lord.
Cost.
Cost, my lord.
You've come against the cost.
My lord, come against the cost, my lord, and my lord, what has happened, my lord, since this order has been passed, my lord, I have not been allowed to, my lord, participate in the, my lord, in the job, my lord. My lord, they have not allowed me to, my lord, to enter into the office, my lord.
But how can we help you in
My
the
lord, this will
contempt
not help, my
application?
lord. But, my lord, for this order, my lord, I have not suppressed anything else, my lord. If your lordship kindly takes pen to the
Want to take time for that?
My lord, Mr. Banerjee, Mr. Amitesh Banerjee is leading me. He is out of Calcutta. He will be coming back tomorrow. My lord, he asked me to take time for that, my lord.
and if this order
He
goes,
cannot, my lord, filing appeal under section 19 is a bar. my lord.
Either you do it or you take
No, my lord,
advantage.
I am not doing
Don't
that.
make double submissions.
My lord, I am burdened to.
Come day after tomorrow.
my lord, affidavit of service be kept there? Or my lord,
Affidavit of service, comma, as filed, comma, be kept on record. Heard Mr. Bhattacharjee, learned advocate appearing for the appellant. Stop today, comma, an adjournment has been prayed for on behalf of the state respondents. Why have you made state? It should be contempt was not filed with the name of the contemners.
yes.
Then why you have
My lord, appeal is also, my lord, against them, my lord.
তাহলে এখানে এরম আসছে cost title
No, my lord, if you're, my lord, this is the initial cause list.
রিটের cost title তো হবে না রিটের cost title হবে এটা তো ভুল করেছো এটা তো রিটের cost title হবে না এইখানে দেখ
My lord, kindly come.
এই cost title টা হবে লিখেছে লাগিয়ে দে তারপর তো আছে এরা কারেক্ট করে today however today comma however comma and
In this matter, I am for the appellate. At the very outset, I like to submit one thing before Lordship. Though, on the last day, I argued for some time, but I could not place some documents. And I had handed over a bunch. Instead thereof, I like to exchange on the another bunch because some other annexure.
Mr. Manna, how long will you keep us?
I will not, and only 2 annexure has been included in this one.
I tell
Only allow me, I am giving a copy to my learned friend so that he cannot be it. On the other day, I am.
So far, my learned friend is concerned, my learned friend may conclude his argument. Your lordship kindly adjourn. I pray for adjourn.
This
I
meeting
am
cannot
yesterday,
Yesterday we are ready. All of us were ready, my lord. I thought he will complete the argument. We will argue, my lord. A minor gams are minor gum surgery has undergone by the ASG. That is why I requested, my lord, not give any
So,
day.
Mr. Manna, no, Mr. Manna, come next day and bring some more documents. We
Can
go
I
on adjourning matters.
take back the earlier copy and instead of this, my lord? If your lordship permits, I
Can you do this? Can you do this in an appeal?
No, it is not the annexures. There is the documents which I like to rely upon.
Can you do so without filing a proper application?
No. It is in course of the hearing. I am referring the documents which has already been annexed in the paper book, but I have compiled it in a separate sheet so that my lord need not take pain to go through the paper book and the supplementary paper. For that reason, I have compiled in a document punch.
Very good. So no,
No, it is not out of record.
it's not out of record.
It is not out of record. But I am giving a advance copy to my learned friend.
petition.
না, সবগুলো ডকুমেন্ট আছে ওই পেপার বুকের আছে। I have given the paper book number also.
Yes,
In
yes,
the bunch, I have.
He has made a convenience volume
Yes.
so that all documents are on record.
If it is all right, no issue, no
It
issue.
is.
No issue.
But I cannot be not include which is not in the paper book.
You tell us when you will be ready.
মানে Monday? Monday my lord went. Minor gum surgery.
Monday is a combined list day. You tell us when you can come and do the matter. This is the state of affairs now. Please agree to a date and agree and let us finish off the matter.
Yes, yes.
আমাদের লোয়ার কোর্টে কত ডেট আছে? মঙ্গলবার কত তারিখ? কোন দিকে মামলা ফিক্স নেই?
8 তারিখে?
But I don't have any difficulties on any day. As per my lord's direction, I will
Mr. Manna,
I will appear as per my lord's direction.
8 July.
But yesterday I could not reach because entire North Calcutta was collapsed. I had to come at 12.
give us the date.
So I have come earlier today.
8 July. জজ সাহেবকে বলছি।
আমার কোনো অসুবিধা নেই।
8 July.
Subject to my lord's convenience. I don't have any objection.
Next Tuesday কি অনেকগুলো আছে কার্তিক?
ওই দুটো কি রিফ্রেশ করতে বললেন জজ সাহেব? ওই দুটো কি নিয়ে নেব আগে দুটো? বলেনি।
কবি কম আছে দুটো।
Well, can I take back those and in place of this? No, on that date. On that date. Very good.
বলে দাও 10
I will.
8 July.
8 July. 10th.
Thank you. Great freedom.
My lord, I beg to appear on behalf of the appellant. This is a civil first appeal, my lord.
Pardon?
This is a civil first appeal hearing. My lord, may I submit one synopsis, your lordship, so that the matter is.
Who is opposing you?
My lords, for the
I'm sorry.
defendants, my lords, I have one particular issue. I would kindly pray to seek to retire from this matter because I'm unable to contact with any of the defendants. I had executed the Wakalatnama a year back. I have thereafter tried calling on phone. Nobody picks up the call. Even if somebody picks up, he says it's a new number. I had also issued letters, my lords, to their addresses in the cause title. It has come back.
But we cannot accept that. Na? You have to take steps for cancellation of your Wakalatnama. That is to be done in the department. That is to be done in the department. What is the suit about?
This is a malicious prosecution suit. My client is a doctor. He filed a suit for malicious prosecution because he was wrongly charged for attempt to rape and
Paper book has been filed.
yes.
Paper book আসেনি আমাদের।
Paper book nahi, একটা আছে। There is only one paper book. Expertise.
No, he must be given a copy of the paper book.
No, I have a copy.
They have
That I have.
So we don't have 2 copies of paper book in the file. আমাদের কাছে আসেনি?
No, I have given 2 copies.
You must have filed in the
I have
department.
filed. ফাইল তো অনেকদিন আগে করেছিলাম, ডিপার্টমেন্টে ফাইল করেছি। এটা তো জানি না কোর্টে এসেছিল কিনা, কিন্তু 2টো ফাইল
ডিপার্টমেন্ট থেকে আনতে হবে তাহলে।
In that case, my lord takes the matter up.
Lordships, I appear for the petitioner. Lordship, I'm led by Mr. Probal Mukherjee, Senior Advocate. He's stuck in Court 36. I'm praying for a short passover.
Is the matter, Mr.
This is with regard to the State Acquisition Act. A company which is no more existing, my lord, then under the State Acquisition Act, the state has the power to resume that particular workshop or factory.
Any paper book prepared?
No, I don't think so. No paper book was prepared.
This is a fresh motion which is appeared.
It had appeared before your lordship when your lordship was sitting with my lord Justice Chatterjee, but thereafter, my lord,
we heard it. Your
lordship heard on 2 occasions, my lord, as far as I can recall, on 2 occasions, your lordship heard the matter.
Assignment.
So this has been assigned to your lordship because land determination is with the honorable division bench presided by my lord Justice Boshar, but it has been assigned. It was released.
Release করেছিল। This has to go. We are taking two other matters.
When your lordship was taking up the land determination, your lordship heard this matter on 2 occasions, my lord, as far as I can recall. Thereafter, this matter went up before my lord Justice, the honorable division presided by my lord Justice Boshar. His lordship was pleased to release the matter on personal ground. Thereafter, it has been assigned before your lordship.
Next Thursday week.
Thursday week. Grateful.
কার্তিক শোনো, এই যে অ্যাসাইনমেন্ট থাকা হয়ে যাচ্ছে না,
I'm appearing on behalf of the state. I'm
you're for state.
on behalf of the state.
This is also assigned to us. What is the matter about? Do you know?
No, but I have no instruction right now, man. That's why I think
file
I prefer this appeal against the order passed by Honorable Justice Vivash Patnaik on August 2024.
এটা হচ্ছে এমআর ডিস্ট্রিক্ট কবে either on 9th or 11th. On that date, it will again happen.
Yes, ma'am.
53, 54 are same.
I don't know.
This was 52. কি 53 ফাইল এটাও মনে হচ্ছে সেম এটাই হবে এই তো ওই সেম ওটার সাথে 54টাও মনে হয় সেম দেখো ফার্স্ট পেজটা বের করো Wait, we have not dismissed your matter.
No, I'm for the private respondent.
We have kept it on the date when we have fixed the analogous matters for here.
Yes, my lord, 9th July. Your lordship.
Take your breath. Take your seat. The 9th July file গুলো না আরো শুক্রবার পাঠিয়ে original site এর একটা আছে 9th July
This 55 and 56 more down for that.
yes when did we hear it Mr. Ghosh
Your lordship was last occasion. Hear it on. I'm giving you that date.
yes
This matter I'm led by Mr. Recruitment MITRA. May I start my letter?
you have finished na
But he is also almost to the verge of Madhapa.
so you start from that stage
Yes. That's my. But last occasion, my learner senior friend was pleased to pose your lordship the impugned order, which is at page 190. The question was, my lord, the only question was, admittedly I could not get the pass mark from class 8 to class 9 final examination. But however, lordship, I was
discretion of the
managing committee was promoted to the class 9.
So that discretion application is supported with a by a document to that effect.
But that I do not I have, but the report of the board says the school authority has the discretion under the management rules to promote. Now the question arose today before your lordship to determine is that whether if lordship kindly consider in that way, suppose in class 8 to class 9 I could not secure pass mark, I promoted to class 9. Thereafter, I continued studies. Up to I studies class 12.
My lord, kindly take up the affidavit in opposition filed by the respondent number 7 in the earlier writ petition. Kindly come to, my lord, page 148.
Yes, 148. You showed us 148, page 151, subclause Roman 6.
151. Why showed it?
No, no, just
I thought, my lord, that I was reaching there. It's my mistake, my lord.
all right, Mr. 148. Yes, the opposition.
Yes, my lord, 151, my lord, subclause 6. Then kindly come to page 153.
So subclause 6 is you this writ petition was preferred by whom, Mr. Mitro?
Yes, yes.
15864 with 15923. These two writ petitions were
One was filed by my client, the other one was by them, by her. By the respondent number 7 in my writ petition, who is the private respondent here also.
Yes. Court directed that board will consider.
Yes, it transpires that the president of the West Bengal Board of Secondary Education had passed an order, the operative portion of which is quoted below. Now, it indicates from the said document that Srimati Shet got such and such marks. Kindly turn the page. She was, fourth line, she was promoted on consideration, but the headmistress could not produce any evidence showing application of residuary power by the school authority. However, she stated that there was a practice in the school for granting promotion in some cases on request from guardians. The attendance register produced by the headmistress shows that Srimati Taposhi, the appellant before your lordship, was permitted to attend classes in class 9 and was given transfer certificate on 23rd November 1990 by the then headmistress, declaring that Taposhi left the school on 22nd May 1987 as a student of class 9. Then kindly come to, my lord, page 153. The continuation of that paragraph about, my lord, 6 lines from the top. But as per Rule 30, Sub-Rule 3 of the Rules for Management of Recognized Non-Government Institutions Aided and Unaided, as amended, the head of the institution, who shall ordinarily be guided by the advice of the Academic Council regarding promotion of students, has the power to overrule the advice of the council. A copy of the said rule is annexed. So, my lord, the headmistress or, my lord, headmaster, headmistress here had the power. My lord, it's nobody's case that, my lord, headmistress did not have power, or, my lord, the council had given a different opinion altogether. Then kindly come to the next subparagraph. After perusing the order dated 28 September 2010, passed by the President of West Bengal Board of Secondary Education, it transpires that it was observed that Srimati Taposhi Shet was promoted on consideration by the headmistress, but the headmistress could not produce any evidence showing application of residuary power by the school authority, and there was a practice in the school for granting promotion in some classes on request from guardians. So this is admitted. Next, it is stated further that the President of West Bengal Board of Secondary Education further indicated that as per Rule 30 Sub-Rule 3 of the rules, as amended, head of the institution shall ordinarily be guided by the advice of Academic Council regarding promotion of students, and the President of the West Bengal Board of Secondary Education further commented that the school authority has some residuary power to promote a student.
But the school authority, Mr. Mitro, may not be the headmistress alone.
It's the council.
Pardon?
It's the council.
Academic council.
Academic council, and, my lord, the This also, my lord, records that the headmistress or the headmaster has the power to overrule any decision of the council. Number one, in any event, my lord, it is nobody's case, my lord, that the council did not agree. It was a decision of the school.
Subparagraph 9.
Paragraph?
Subparagraph 9. 9.
Yes, I shall come to. I shall come to. In the order passed by the President of West Bengal Board of Secondary Education, there is no comment and or indication that the head of the institution, whether by special reason to be recorded in writing, overruled the advice of the council. And it is stated that no action was taken in terms of Rule 30, Sub-Rule 3 of the Management Rules. There is, my lord, nobody says that the council took a contrary view.
So why are they saying this?
I do not know. There has to be a basis of this, my lord. They have said that. I could have understood that the affidavit says that the council took a contrary decision and the headmistress overruled that. I could have understood that. That case has not been made out. In any event, they themselves say that the headmistress has the power as per the rules. They quote the rules. Then next, it is further stated that there cannot be a practice for grant of promotion on the request of guardian. It is stated further that the incident relates to the year 1986 and it appears that one MB Dash secured such and such marks, etc. Then kindly turn the page.
So MB Das was not given, but Taposhi was given.
Yes.
Though they secured the same marks.
Now, my lord, I really do not know, my lord. There can be, my lord, a situation where Taposhi was, my lord, a better student, my lord, during, my lord, the previous examinations. Those are taken into consideration.
Mr. Mitra, can you show us Rule 33, 30 Sub-Rule 3?
It's annexed, my lord. I will.
Or we allow you to proceed.
No, no, I will show you. এটা কোথায় আছে বলো? Kindly give me a minute. Sir. Let kindly come to page 145. Yes, yes. Kindly come to page 145. Sub-rule 3 is at bottom.
Shall ordinarily be guided by the council. The head of the paper reasons in record. 8
parties. Now, my lord, in that,
Which report question?
this report,
This progress report?
yes, no,
Page 73, order.
the president's
73, yes.
sorry, the director's report, not president, the director's report. It was challenged by both. Now, in that, my lord, an order was passed. Kindly come to page 141. Page 141, my lord, the order dated 9th August 2010. The President, West Bengal Board of Secondary Education is not a respondent, etc. Kindly come to the last paragraph. Be that as it may, without expressing any further opinion on the issue, this court considers it proper to obtain a report from the President of the Board as to whether on the basis of the marks obtained by Srimati Taposhi Sheet at the half-yearly and annual examination of 1986 conducted by the said Vidyamundi vis-a-vis the rules regulations of the board that were existing at the time, she took half-yearly and annual examination referred to above, she could be declared to have been promoted to class 9. The President of the board shall decide the issue upon granting both of them, upon granting so and so, and the authority of the school reasonable opportunity of being heard. The report shall be placed before this court. Then the President shall also indicate in his report as to whether the school authority enjoys any residuary power to promote a student, although she may not have been qualified for promotion according to the board's rules regulations. Now kindly come to the next page. The report.
Then what happens to the order of the director?
That goes, my lord.
Has it been recorded that we are setting aside that order?
That was challenged. That was challenged in the writ, and my lord, this report was called for.
Yes.
Now, kindly come to page 143. Second paragraph. Srimati Taposhi Sheet, Srimati Bithika Singho, Sri Prashanto Kumar Bera, Secretary of this school, Sri Tapan Kumar Pal, Teacher in charge of this school, and the headmistress.
Of the school means in which appointment was given. Now, this school means school from which she passed. Pachkul.
Pachkul, yes.
That is the school she passed. Yes. Oh, achha. Oh, that school was a party to the writ petitioners. Must be.
I'll check that one. School was directed to be given a hearing, my lord.
What is the name of the school?
Bachkul. Malai Chandra Vidyapit.
Now, Bachkul
was a party.
Bachkul is the school in which you got appointment. 124. Bachkul is the school where you got
Yes, I made a mistake.
Not the school where
vacancy in the post of grade D staff in Bachkul. And my lord, the school she read, my lord, was Bhupati Nagar Konna Vidyalaya.
That school was not a party.
No, but they were given a hearing.
They were given?
Yes.
In the order, director's order, they were there.
They were a party.
Director's order is at page 71. Bithika Dijai, additionally a secretary Bachkul, headmistress Bachkul. No, school was not there.
Yes, my lord, respondent number 8 here, my lord, kindly come to. Did copy and expert?
The stuff in Pachkul Balay.
যেখানে পাঁচ চাকরি পেল সেখানে
স্কুল পড়েছে
প্রতিনগর। What is head?
Was a party matter in the date.
Bharatnagar Konna Vidyalaya.
Bhupati Nagar, kindly come to page 31.
Yes.
This is my writ, my lord, which starts at page 23.
Challenging the order of the director.
Yes.
Oh, Bhupati was a party. Very good.
And my lord, I will try to find out whether, my lord, in the other writ, she was the school was a party.
Page 100.
Yes, it starts at page 99 onwards. No, that school was not. Be that as it may, my lord, the
now report was called for from the board.
president of the
Matter
board,
was
my
keep-
lord,
Uh,
I was placing page 143.
which goes in your favor.
Yes, 143. Kindly see, all were given hearing, and then kindly turn the page.
What's this? রিপোর্টটা কল করবে ওরে বললো আমি পাঠার রাখছি page 140.
Kindly turn the page, kindly come to page 144.
That we stopped. Yes.
Kindly come to the second paragraph. Page 144. The attendance register produced by the headmistress shows that Srimati Taposhi Sheet was permitted to attend classes in class 9 and was given transfer certificate original on 23rd November 1990 by the then headmistress of Bhupatinagar Kunna Vidyalaya, declaring that Taposhi left the school on 22nd May 87 as a student of class 9. It also indicates from the...
Where is that transfer certificate is not on record, no?
No, that's not.
Achhe,
I'm sorry.
Acha.
May I read, my lord? I shall show that. Kindly omit, my lord, the next paragraph. Kindly come to the paragraph thereafter. It may be mentioned in this connection that according to the norms in the board syllabus prevailing in 1986, pass mark in a group. Sorry, my lord, kindly come to the previous paragraph.
Yes.
It also indicates from the consolidated score sheet of interview for recruitment of Group D staff that out of 29 candidates, Srimati Sheet was selected, securing total 31 marks. Her academic qualification was shown as D. And date of birth 11 September, while Srimati Bithika Singho secured 27 marks with her qualification MP and date of birth such and such. D আর MP টা কি বলছো?
certificate. Class 8 fail.
না, was shown class 9, D নয়. Was shown class 9.
প্রমোশন তো পেয়েছে দশে অ্যাপিয়ার করেছে টিকা তাপসী
He was appointed, my lord, in 2008.
2008 না
20th September 2008. এটা কোথায় আছে? Transfer certificate.
so in the appeal you are enjoying any interim order you are serving or you are out
status quo was to be maintained.
No, no.
No, no.
এই appeal status quo দেখ ভালো করে দেখ এইভাবে আপনি কপি ছিল দেখেছি হ্যাঁ এই তো চিত্র
After hearing the order of reinstatement cannot be Fund 2003 by panel that discussed the final 24th May 24
exactly that's all
Yes.
order.
24th May.
Cancellation, no reinstatement cannot be done. That's the interim order.
After hearing the learned counsel for the parties, we are of the view that the order of reinstatement cannot be passed at this stage and the appointment of appellant, as the appellant has been challenged, the direction with regard to the recasting of the panel may continue, but no final decision shall be taken.
যেটা ওই এসপি তালুকদার ওরা 2008 এত বছর চাপ তাই So, Mr. Sannal, you did not oppose his approval of appointment given by the DI? During pendency, these things happened.
Well, if the
Interview was on 2000, interview ta hoyeche 2008. So after date, she was appointed, her panel was also approved.
that was the Honorable Justice Datta said no equity should be claimed.
Yes, yes.
No equity should be claimed. Entire thing was questioned.
Yes, Mr.
Yes. Now, Lordships wanted to see, my lord, the transfer certificate. Sorry, my lord, it's at page 52.
Page 52.
Yes.
Yes.
Now, my lord, kindly once come back to, my lord, page 144.
Yes.
I showed you, Lordship, the second, third paragraph. It also indicates, etc. Next paragraph. It may be mentioned in this connection that according to the norms.
Now, Mr. Mitra, please read the previous paragraph. It also indicates.
It also indicates from the consolidated score sheet of interview for recruitment of Group D staff that out of 29 candidates, Srimati Sheet Dhali was selected, securing total 31 marks. Her academic qualification was shown 9. It's not D, my lord. I read it D. It's 9. And date of birth 11 September 72. While Srimati Bithika Singho Bormon secured 27 marks with her qualification MP and date of birth 23rd January 1983.
Bithika Singho. না না তারপরে উইথ হার কোয়ালিফিকেশন এমপি মাধ্যমিক পাস ওটা আমি তো বললেন but she studied in class 10. Yes, then it may be mentioned in this connection.
It may be mentioned in this connection that according to the norms, in the board syllabus prevailing in 1986, pass mark in a group was 34% and minimum qualifying mark in a subject was 20%, stipulating condition that this principle may be followed by the schools in the annual examination. But as per the Rule 30 Subrule 3 of the Rules of Management of Recognized Non-Government Institutions, as amended, the head of the institution, who shall ordinarily be guided by the advice of the Academic Council regarding promotion of students, has the power to overrule the advice of the council. A copy of the said rules is enclosed. It therefore follows that the school authority has some residuary power to promote a student. Now, as I was submitting, my lord, this report of the president was not challenged.
They did not challenge this in their writ petition. Because this was during pendency of the writ petition.
Yes. Yes.
So when the writ petition was filed, there was no scope for challenge.
There was no scope for challenging. Then, my lord, kindly come to.
Now, please show us the rule.
Kindly come to, my lord, the next order which was passed. Kindly come to page 147.
Oh. 147 or 145? Rule 30 is at page 145.
No. The next order passed by Justice Dotto, my lord.
Oh, achha, achha.
Page 147.
Achha.
Second paragraph.
Same be written, shall not you to take exception to the report.
Now, this is an order of 9th of December 2010. Now, kindly look into the affidavit which Bithika filed in my application. Kindly come to, my lord, which I was placing. It starts at page 148. Kindly come to page 165. This affidavit was affirmed in 2016.
No exception was taken.
I subject to correction. My reading is, my lord, that there is no exception. I place different portions of this affidavit. Subject to correction again, my lord, I don't think, my lord, that there is any exception to the report filed by the president. Now, kindly come back to the to their affidavit. Kindly come to page 155. Kindly come to page 155.
Yes.
Subparagraph 11 at the top. I placed up to 154 possibly. Kindly come to page 155. An application was submitted by the husband of Bithika that is, my lord, the respondent, before the Secretary, West Bengal Board of Secondary Education, seeking certain information under the Right to Information Act. Pursuant to the application submitted by the husband, it transpires that the State Public Information Officer submitted information, a copy of the information is annexed. Now kindly come to page 176. These are the questions put, information sought, page 176. First question, has the headmaster, headmistress any residuary power to promote student in the examination? What were the norms of passing class 8 in 1986? Please respond to this question with documentary evidence. A student of class 8 has failed in all subjects except the work education, etc. Under such circumstances, is he/she eligible for passing the annual examination? Was there any no detention scheme in case of promotion in 1986? Now kindly come to the answer at next page. Page 177, the board's response. In response to the above application, the relevant department has informed that 1. In terms of Rule 30, Sub-Rule 3 of the Management Rules, for aided, unaided, non-government schools, institutions, the head of the institution shall ordinarily be guided by the advice of the academic council in the matter of promotion of students in the examination, but the head of the institution may, for reasons to be recorded in writing, overrule the advice of the academic council. In that case, any member of the ACA council may be in disagreement with the decision taken by the headmaster. Then the matter may be referred to the managing committee of the school, whose decision thereon shall be final. Kindly come to the next page. The general norm of passing any student in any class in 1986 was that the student shall have to obtain pass mark in all subjects, however, in exceptional circumstances. Results, that is promotion, are generally discussed in the academic council, whose decision may be referred to the MC for consideration and final decision. After the implementation of the comprehensive and continuous evaluation system since 2007, some criteria have been introduced for promotion of students in different classes, which have been published by the board. As stated in the query, etc., the student is not eligible for passing the annual examination. Then in 1986, there was no detention policy at the primary level. Not in the secondary level for promotion. Now kindly come back to page 155. Subparagraph 12. No decision of the managing committee of this school has been referred before the West Bengal Board of Secondary Education in respect of promotion of Taposhi Sheth. It was not, my lord, the one of the questions, be that as it may. No decision of academic council was also placed before the West Bengal Board of Secondary Education in respect of promotion of Taposhi Sheth. Since no decision of academic council of the managing committee of the school has been taken and was never placed before the West Bengal Board of Secondary Education, it cannot be contended that Taposhi had been promoted to from class 8 to class 9, exercising any residuary power. It is stated further that the husband of Bithika again submitted another application seeking information from the administrator of West Bengal Board of Secondary Education. Now kindly come to page 179. Kindly come to page 180. Questions put, or my lord, the information sought. Now my question is whether Taposhi is eligible for passing the annual examination of class 8, which was held in 1986. Was there any provision for passing annual examination of promotion on consideration in the year 1986. Was there any rule to pass any student who got minimum marks? Please show the copy. According to the board rules, Taposhi, whether pass or fail. Academic council can give promotion to sit on higher class of student who passes only in one subject. Now kindly come to the answer, page 181. In response to the aforesaid application, the relevant department has informed that as per annual mark sheet, kindly omit that, kindly come to 2. Under special circumstances, if the MC and academic council of the teachers consider the result of such candidate and approve it with a resolution adopted unanimously in the meeting by the majority members specifying genuine reason behind such poor result of the candidate and expecting better result in the next class, the school authority may allow her promotion to next class on consideration. Then 3 and 4. It is the normal rule to pass any student who shall have to get at least such and such marks, 34% marks. Considering the pros and cons of the student, scholastic and non-scholastic aspect throughout the year, in teaching and learning situations in different classes, academic council may recommend any student for promotion with the help of resolution taken unanimously in the meeting of academic council as a special case.
But that report has not been produced.
That report has not been. That report was not called for. That report was not produced. And again, my lord, with greatest of respect, I really do not know, my lord, how many schools, my lord, after 24 years or my lord, so 86 or 14 years, 86, and 2010, 24 years. How many schools would be in a position to produce such records?
What weight with the learned single judge?
I shall show your lordships now. Now kindly come to the order. Page 190. Two. My lord, may I proceed on the basis of the internal page, my lord? Kindly come to my lord, page, internal page 5. Second paragraph. Taking me to annexure or internal page 5.
Yes.
Taking me to annexure output to the affidavit in opposition used by Bithika as private respondent number 7 to Taposhi's writ petition. It is contended by him that while giving response to application of one Shopon Kumar Borman preferred under the relevant provisions of the Right to Information Act, the West Bengal Board of Secondary Education declared that Taposhi could not be declared to be class 8 pass candidate I have shown this. I have shown your lordship the question put and the answer, my lord, page 176, 177. My attention was drawn to annexure R5 of the same affidavit to contain that though in the same academic year some students secured more marks than Taposhi, but it was only Taposhi who was promoted to class 9. Again, my lord, with greatest of respect, that is not, my lord, the answer. Those are at page 179 to 181.
Then where from did the court get this? That persons who secured more marks than Taposhi, that though in the same academy some students secured more marks than Taposhi, but it was only Taposhi who was right.
Do not, so, my lord, that could have been the allegation of the petitioner. That could have been the allegation of the petitioner, but that will not appear.
No, that is page 179, Mr.
Yes, kindly come to my lord, page 176 onwards, my lord.
Page 179, the marks have been given.
Yes.
Taposhi secured 160. This is right. 8%. এদের প্রমোশন হয়নি। ওদের প্রমোশন হয়েছে কিনা কি করে যাবো, কেননা দিস ইজ ইন রিপ্লাই টু দি আরটিএ। হ্যাঁ, বিকজ দি কোয়েশ্চেন ওয়াজ, এইটা তো ইন রেসপন্স টু আরটিআই অ্যাপ্লিকেশন।
না, এটা হচ্ছে আরটিআই অ্যাপ্লিকেশন।
My lord, kindly come to page 179. This is what the husband of my lord Bithika gave. I presume that this to be correct. I presume this chart to be correct. Now kindly look into the questions. The questions do not possibly speak about, my lord, the other candidates. Page 180. Then kindly come to page 181.
According to the annual mark sheet register, এটা রেজিস্টারটা প্রডিউসড হয়েছে দেখতে হবে।
Report will reveal that Taposhi secured only 169 marks out of 900 marks, and she failed to secure qualifying marks in any of the 3 subject-wise groups. She was awarded 38 of 100 marks in works education. Admittedly, in oral examination of second language, Taposhi was awarded 11 marks out of 10. In the report of the board, in unequivocal terms, it was declared that Taposhi would secured 54 marks out of 300 in language group, 40 marks out of 300 in science group, and 37 marks out of 200 in group of India. And her people has failed to pass class 8 examination. As such, having failed to secure 30% in the aforesaid 3 subject-wise groups, she could not pass the annual examination of class 8. Taposhi was promoted to class 9 on consideration. From annexure R5 as referred above, it would be explicit that a certain number of students securing more marks than Taposhi had not been considered for promotion. Now, this will not appear from R5. From annexure R5 as referred above, it would be explicit that a certain number of students securing more marks than Taposhi had not been considered for promotion to the next class by the school authority. But for some mysterious reason, Taposhi was promoted. The school authority concerned, under the impression of having unfettered power to award promotion, promoted Taposhi to next class. Taposhi did not continue her studies but utilized her progress report to secure a job. Well, with respect, my lord, she left the school in 1987. She got the job in 2008. Now, my lord, nobody possibly could have thought, my lord, that after 20 years, my lord, a vacancy would crop up and I shall apply there. And that is how I manage it. I really, my lord, it is unfortunate to comment that a school authority which comprised of respectable teachers engaged in building moral character of students and imparting quality education to them for the reason best known to them had promoted Taposhi to next class, keeping either other identical circumstance students stuck to their old class only to facilitate her to use such progress report as a class 8 pass student. Now, my lord, again, my lord, pausing here for a moment. Hey, it was nobody's case. It was not the case, my lord. The school authority had no authority to do this, no power to do this.
No, there was no allegation in the opposition that there was a collusion between.
No, there was none. There was none. And my lord, the learned judge proceed on the basis that I managed to get the certificate. I left the school with the hope of getting the job. Had it been on the same year, my lord, possibly it would have been correct. Not after, my lord, 20 years. Or 21 years.
We don't know, Mr. Mitra, whether you participated in any other selection process during these 20 years on.
No idea.
Yes.
But may I read it? It is unfortunate to comment that a school authority which comprised of respectable teachers engaged in building moral character of the students and imparting quality education to them for the reasons best known to them had promoted Taposhi to next class. I pause here for a moment. The committee had the authority to do that. That is, my lord, the report of the president. That is the report, my lord. The report which is unchallenged. And then, keeping other identical circumstance students stuck to their old class, my lord. Whose case is this? If I may ask myself the question, it was nobody's case. Next paragraph. In this legal battlefield, Taposhi suffered a serious blow when a coordinate bench of this court in its order dated 30th April 2009, passed in WP number such and such, observed that the private respondent did not, in fact, qualify in the examination held for class 8. Taposhi accelerated her defeat, leaving the order dated 30th April 2009 unchallenged. Now it was sent before the board for consideration. Why should I challenge if I have nothing to, my lord, worry about? It's not that my employment was set aside. By this order of 30th April, the director of school education was told to give a report, to consider and give a report. In a quick succession, she suffered another blow when the board in its report in unambiguous words declared that Taposhi could not pass class 8 examination.
Yes.
In a quick succession, she suffered another blow when the board in its report in unambiguous words declared that Taposhi could not pass class 8 examination, and eventually she suffered a fatal blow from the order of the director of school education, in which her candidature was cancelled. Now, তো রিপোর্ট কোথা থেকে এলো? এই বোর্ডেরটা কোনটি? সে তো পড়েই। The learned advocate tried to rescue Taposhi from the jaws of defeat, asserting that promotion to class 9 should be construed to passing of class 8, but the school authority concerned could not justify such promotion before the board. Well, it's completely contrary to the report of, my lord, the president. Completely contrary to the report of, my lord, the president. Dated, my lord, 28 September 2010. Then, my lord, kindly suffice it to observe that a decision is an authority for what it decides and not what can logically be deducted therefrom. Even a slight distinction in fact or an additional fact may make a lot of difference in decision-making process. The judgment is a precedent for the issue of law that it raised. In the case at hand, an advertisement applications were invited from eligible and intending candidates for the post, and as such, the decision of so-and-so is distinguishable on facts. Moreover, Taposhi did not challenge appearance of Bithika in the interview. She even did not challenge the observation. The learned advocate tried to draw sympathy from the court in his impassioned submission, which gives reminder to the legal maxim, which means law is hard, but it is the law. A decision of a court should not be influenced by any impertinent consideration. Showing sympathy on an illegally appointed candidate would be misplaced sympathy, which is also fatal to justice delivery system. The director of school education cancelled the candidature of Taposhi, but simultaneously he cancelled the prior permission, approval of panel, appointment of Taposhi, approval of her appointment, and directed reference of the vacancy to the commission. Therefore, next question comes for resolution is whether or not this concluding part of the order of the director, whereby he cancelled the prior permission and directed reference of the vacancy to the commission, can be sustained. In this context, I hasten to reiterate the proposition laid down by a coordinate bench of this court in WPA number such and such, with approval that there is no justification to deny appointment. He goes on referring to cases. I really do not know who cited these cases, be that as it may. Kindly come to page 11. Therefore, from the discussion at the top, therefore, from the discussion made herein above, the only analogy which can be drawn is that as Taposhi could not pass class 8 examination, she was not eligible for the post, and her appointment is in the post is void ab initio. A complete go by to the rules, to the report, submitted by, my lord, the president of the board, which remained unchallenged.
Yes.
My lord, in that view of the matter, my lord, in my full submission, the order impugned which completely, my lord, glosses aside the report of the president of the board, does not take into consideration those facts, does not take into consideration the fact that the school authority, my lord, has the power to promote a student, my lord, is liable to be, my lord, and should be set aside. My lord, may I have your lordship sleep for 5 minutes?
Yes, yes. Yes, yes.
For the purpose of showing the recruitment qualifications, because it takes us to the question of eligibility of a candidate to be considered or to apply for. The judgment quotes this rule. This appears 2 pages, 67 or 132 of the judgment of order of Justice Talukdar. If your losses, which one is considering your losses? Page 132, page 67, both appears. Anyone can your losses take it up. Justice Talukdar's order.
Which one are you taking?
Anyone, Malana.
You tell us.
I'm at your losses.
No, no. We want to.
Page 132, your losses take it up.
This was the first writ petition preferred. But you have not brought that writ petition on record.
No, copy আছে তো এটা petition. Now I take your losses. Leave aside my submissions. The rule was quoted at page 132, last paragraph. It clearly appears that the qualification for appointment of a group D staff in a school shall be a certificate of passing class 8 from a recognized school. My lord, the progress report is not a pass certificate here.
Where have you taken that point? Nowhere you have taken that point.
Look, that's a legal point. That's a point of law. Eligibility criteria. That's our point in the writ petition. That he was that's not qualified.
Show us that non-production of the certificate.
No, non-production is not.
Certificate is not there, you are saying.
No. I am saying, your lordships, progress report doesn't say he has passed the examination. Passing the examination and promotion on consideration to different things. Why I am explaining it to your lordships. Promotion on consideration, apart from the power, I will take your lordships to this. My learned senior friend has argued much, I will take your lord. Promotion under consideration is confined only to the next class admission. It doesn't mean pass. When you are applying for a public employment, you have to satisfy this requirement of passing class 8.
This was never your point, Mr. Sharma.
Look, this was all throughout this was the point.
Show us anywhere you have taken, where is your argument to that effect?
Look, that's your losses. Will find your losses. Kindly, take your losses. In this order.
A very serious thing.
Kindly see
saying that forget about everything. Admittedly, no.
Forget out not but for the timing. I will take all these points.
No,
I
but
will deal with.
first show
The
us.
first LOC, page 132. Again. Don't kindly see the second paragraph.
No, there is no dispute that this is the recruitment.
No, I'm not.
Your contention.
That's I'm showing you, LOC, page 132. The petitioner who, referring the backdrop of the present case, submits that the private respondent who has been appointed was not even eligible to be considered. From the very first day, I'm questioning this. Then, my lord, kindly consider my submissions before the court. Not even any subject he passed. Far less your loss is more marks given than the allotted marks. The 11 was given out of 10. But does it require any scrutiny of any court of law? I'm asking to myself. This sort of candidate placing, arguing for public employment. This is not the pass. Pass means he has passed the examination according to the norms. Promotion under consideration, your lordship, means that he is promoted for the next class admission in the school internal management. He cannot use that promotion under consideration.
You may have argued, but this has gone down in the order of the director of school education, then president of the board, then the high court. Nowhere this point was even dealt with by the director.
I tell you, losses.
That
In other way or other, they have dealt with everywhere. I will show you losses. In everywhere, I will show you losses. This is my first contention when I moved the first petition.
Maybe,
and
but
then your losses kindly consider page 133. Question, last paragraph. Question first arises as to whether the present petitioner can challenge such appointment on the basis of such progress report being annexed at P5. It is clear that the private respondent did not in fact qualify in the examination held for class 8. That's why the learned single judge says this finding you didn't question. Out of the total marks of 900, he could not even get the total qualifying marks. He got only 169, my lord. It cannot be denied that he was promoted, but was the nature of consideration for such promotion is not certainly clear from the said document. So from the very beginning, it was doubt this exercise of power, if any at all. The progress report does not specifically mention that he was considered as a class 8 passed candidate. It sometimes happens that a student is given such promotion in order to enable him to enjoy a higher class in another institution, but it is not the issue by adjudication for this court. My lord, I could have understood, my lord, a student have failed in one subject and the court considered him for consideration for promotion in the next class because he has failed only one subject. He has failed in all the subjects. See, promotion under consideration. And that should be treated as passed to satisfy the eligibility criteria. Then, my lord, ultimately, it left upon the, my lord, the authorities to consider. None of the authorities says the qualified the eligibility criteria, fulfill the eligibility criteria.
Show us one line that any of the authorities said that he has not passed.
I take your loss. Then after this, my lord, the order was passed by the director of school education.
Yes, Mr. Ghosh, did you produce any certificate of passing? No. Apart from that page 143.
My lord, I am not saying certificate.
I produced my certificate.
Progress report.
Progress report and the transfer certificate.
And
the transfer certificate.
That is page 143.
My lord, I will take your losses to the transfer certificate also.
Page 50.
Yes. It says he was reading in class.
No. That annex chart.
So that's
that progress report.
Progress report is
125.
125.
Kindly show the remarks. Promotion under consideration. Remarks. No pass. Normally, remarks column says first division, third division, second division, pass. Compartmental like this. Promotion under consideration. And under consideration, if we go by the dictionary meaning, my lord, still under consideration.
On consideration.
On consideration.
Yes.
Now, your lordships, kindly see the first order of the Director of School Education. I will take your lordships. Page, your lordship, starts from the page 136. Page 138.
In the matter of promotion of students in terms of 33, it is an ordinary guided by advice.
আমি তো শেষ করছি আমি স্যারকে তো বললাম আরেকটু টানুন স্যার বলতে পারবে মার খাবো নাকি হ্যাঁ আরেকটু টানতে হবে
Certificate that he had passed. So you have produced only page
125.
125. Any other
Living certificate. And the school living certificate.
Where is that?
Page 52.
Page 50.
52. This was issued on 23rd November 1990.
Not related to that.
It says she was reading in class 9.
But the fact is you did not pass class 8.
But I have not suppressed any fact before any authority. If that if it is the if I want a if I procure this document or if I
there is no allegation.
I never suppress any fact before any authority because they have the petitioner when filed the writ petition, the first writ petition, she herself.
No, we are not on. We have understood your argument. We are not on that. We have heard you. We are asking you a question. Page 52 and page 125 are the two documents.
Yes.
Now these two documents shows that you were promoted to class 9.
Yes.
Now please come to page 177.
I got your lordship point whether I'm a class 8 passed or not.
But
now may I have an answer to that?
Promotion of students.
I have an answer to that. But suppose on promotion I promoted to class 9. Thereafter I passed class 10 examination or graduation. Subsequently, a group D post was declared vacant. I applied for the post, saying that, see, I'm a class 8 pass, I'm a 8 pass because I already completed my graduation. And at that juncture, it will be a question that, no, you have not class 8, you have not passed class 8. So I have subsequently passed my graduation.
No, the rule upon which you are placing reliance, 30 sub-rule 2 says that yes, headmaster has the jurisdiction to consider even if there is a contrary decision of academic council.
Yes, ma'am.
Academic council, no decision has been produced. What reason was applied, that is not there because the school records are not in. We understand. But the recruitment rule says that then the criteria for recruitment would have been certificate of promotion, not of certificate of passing.
That what I
keep this in mind, and in reply you make your submission. Yes.
Now, my lord, this your lordships, after the Justice Talukdar's order, this was considered by the Director of School Education. This was again my point, 136. Kindly see the second paragraph. The learned advocate for the petitioner submitted a written note on argument as stated below.
Page 136.
136. I have to satisfy your lordship that this was my argument all throughout. That under the the learned advocate for the petitioner submitted a written note on argument as stated below. That a vacancy occasion in the post of Group D staff in the Bajpul Balai Chandra Vidyapith hereinafter referred to as the said school, and accordingly the school authority sought prior permission from the district inspector of schools Purbo Medinipur to fill up the said post, and pursuant thereto, the said district issued a prior permission memorandum incorporating therein the qualification for the post of group D staff to be class 8 passed, and declared the post to be reserved for such. Upon availing prior permission, kindly see next paragraph thereafter. Challenging the illegal selection of the Srimati Taposhi Datta group D staff and the inaction within the petitioner preferred an application contested hearing, and then your loss is this. The sole contention of the Taposhi Datta that the petitioner, having participated in the selection process, cannot challenge the same and had been negated by the honor.
Produce the headmaster manual, the criteria
For Group D.
Group D. Yes, I have the
non-teaching staff rules of 2005. That is School Service Commission.
Yes, yes.
2005.
Five
2000
rules.
huh? This is recruitment non-teaching staff rules 2005.
2005 rules, your lordships.
This is by the after the commission came 97.
97 Balram non-teaching staff came after 2009 or 10.
Show us that rule.
Rule. That's your lordships. The rule I'm handing up to your lordships. Your lordships, I just put a tick mark, otherwise your lordships would be very difficult to find it out. Done. Rule 4. So many days have gone, that's why I also forgotten when the school service. Now kindly your lordships the rules. My lord, rule 4, qualifications. My lord, kindly see C. At the bottom C, the qualifications for appointment of group D staff in a school shall be as follows. As you also got that one. Rule 4, qualifications at the below, before explanation.
Got it.
A certificate of passing class 8 from a recognized school. Not I'm on passing. Promotion is an internal matter. Malad, I can deal with my learned friend submissions also. That probably my learned friend, after doing this, Malad, he even declared to be a Malad postgraduate, PhD. But that doesn't the qualification. Qualification requirement that class 8 you have passed. Now I will show you lordship. In the Malad approval panel, all of them has shown class 8 is passed against him. How? I will show other documents. Everywhere they say class 8 is passed. You can't write this unless remarks column says denotes my degree, my quality. If I got above 60%, they will write first division. All of our marks sheet shows that, your lordships. If I got above 45 but below 60, second division. 30, above 30, below 45, third division.
So if I am given promotion, it will mean that I have failed.
Malad, I get your losses point.
Failure and promotion.
I get your losses point. When I go for public employment, on the basis of qualification class 8, and I have only that qualification alone, then I have to show that I have passed. Am I clear to your lordships? If I go for public employment, certificate na pass লিখতে হবে তো মার্কশিটে দেখ ক্লাস 9 এ হলে তো হয় না সেটা আবার তাতে অন্য জিনিস তাতেও পারবে না
Mr. Sannal, please assist. Every selection is on the basis of that promotion certificate.
Matlab, not
Every selection.
promotion means not promotion on consideration. Not. How could it be promotion on consideration unless I pass? But kindly see the marks even. That's I'm giving you an example. I will take to their exercise of power.
Kindly see the time taken also. We will kindly see the marks, but you see the time taken. 86, the lady passed, promoted. Point is being raised in 2000.
No, because
because you don't know.
And when he placed himself or herself for employment.
It is not a case that she has colluded with the school.
Collusion, I will come up. Collusion was one thing. A case had.
No, Mr. Sannal, please tell us that this distinction which you are trying to make between pass and promoted.
Promoted on consideration.
Promoted.
Which, kindly, I request your losses repeatedly.
No,
with the marks he got. This is a very ugly affair, my lord.
I don't pass. My school says that for betterment of your future.
Your losses cannot make it. I can take your losses. Your losses has got 61. I always get 59. I can your losses equate the 59 and 61. That these are the difference of marks. Now your losses, can you beat it? A person in the pass certificate given 11 out of 10. And this is a pass certificate has to be considered for public employment. It takes us to what, my lord? None of the subject he passed, promotion on consideration. That's why from the very first judgments, this honorable court questioned it. And because of the court proceedings takes time.
Mr. Sannal, this lady on that progress report of promoted on consideration. Just suppose she sat for the board exam.
Passed it.
And passed. Class
In
10. Will the board exam, will the certificate of class 10 boards be questioned because she was promoted on consideration in class 8?
No, that's not, I tell you, losses. That's why I'm telling you, losses, what the difference? Difference, promotion, and your losses on hypothetical basis.
I'm asking.
I tell you, losses. On these marks, no promotion can be granted. Promotion granted when I tell you losses. I don't know.
Sir, my lord's question.
That I'm questioning.
Marks, all right. Marks. We are on promotion on consideration.
Promotion on consideration.
Mark is there, promoted. If your lordship kindly takes 1 to 125, at the bottom, remark of the headmaster. Kindly take 125. At the bottom, your lordship would find your remarks of the headmaster. That is promoted.
125.
At the bottom, remark of the headmaster, right hand side bottom.
Where it is written promoted. Promoted on consideration.
No, right hand side bottom.
এটা বলছে
ওটা বোধহয় ওনার সিগনেচার
promoted.
এখানে লেখা
হ্যাঁ ওটাই তো বলছেন জজ স্যার প্রমোটেড অন কনসিডারেশন আছে
where
bottom.
That is his signature.
Extreme right below bottom. Remarks of the headmaster bottom below.
Yes.
Remarks of the headmaster promoted.
Where you are getting promoted, that is the signature of the administration.
It has been written promoted.
Horizontal it is written.
That's promoted.
Horizontal again. Not bottom. He's saying
that's
promotion on.
No, there is no other.
On consideration.
And the bottom one is 22/12/86. The word beside that. That is the signature.
I still corrected.
ওটা সিগনেচার রাইট ভাবে উল্টো করে লেখা আছে এটা প্রমোটেড অন কনসিডারেশন
What class is
May I answer to your losses query? Now, when with this, suppose your losses, he passed the even with the first division, the Madhyamik examination. She will apply with that, not with class 8 certificate. Nobody will go back to see how much he secured in class 4, then class 8, then class 9. Her qualification would be treated as the qualification. Now, here your losses. She applied on the basis of that mark sheet alone. That hypothetical situation should not be considered. when the actual state of affairs available before your lordships. He will never, no human being.
No, I'm trying to understand. We are both trying to understand. Is there a difference between promotion and pass?
That's true. I tell you, lordship, promotion on consideration. That's what I'm trying to explain. Like, this is a very ugly situation.
No, forget the on consideration bit.
Promotion.
Just promotion and pass. I have passed class 8 or I have been promoted to class 9. What would be the difference if
Well, I tell you, lordships, in mark sheet, either it will be written pass or
it could also be written promoted.
Not promoted, written, always written promoted on consideration.
No, it can simply say promoted. Will the word promoted not mean that it's a pass certificate?
Then, my lord, he has to secure the pass marks. He has to secure the pass. Promotion in Bengali terms, uttirno, means he has passed the examination. Then on consideration will not be there. এবং promoted means he has passed.
So when the words on consideration comes, you are saying that
on consideration means
not promotion.
he has
not a pass.
He has been passed, he has been promoted. Just to avail of the next class, I'm giving the example when this power should be exercised. Suppose there are 10 subjects in Madhyamik examination.
Let's say 1 mark.
1 marks, or your loss of 1 paper, and these teachers know very well the student. Then this promotion consideration is given. Not for a student failed in all subjects.
No, I didn't follow. What did you say?
I say, your lordship, promotion on consideration is exercised by the school. Suppose out of 10 8 subjects, 1 candidate failed in 1 subject. I will take your lordship to report when this is done. Guardians met the authorities, requested them, these are the situations, please allow my word to go for the next. And the teachers are all well acquainted with the students. They thought that for 1 subject, he should not be kept for 1 year in the same class, then promoted. This is the promotion on
upon promotion, now he passes all the subjects in class 9.
9. Then 10. Well, that's
10.
10.
If he had passed here in this case, he did not, class 9 pass also was not there.
Not there.
But visualize a case where you are right. 6 subjects, 1 subject I failed for 1 mark. Guardians go and say, don't ask them to repeat the year, place him in promotion.
And that request is also to the subject to the consideration of the school.
Right. Now suppose they promote me and I pass all the subjects in class 9.
It has happened.
Now, then when I go for a participation in a public recruitment, I will say that I have passed class 9C. So past class 9 will not take us to a situation whether I obtain pass mark in all the subjects.
Certainly. Well, that's the point I'm taking, your lordship. Because why? Why? Whatever was the lacking in class 8, by dint of merit, he showed that was not actual state.
Right, but I cannot show the class 9 certificate, pass certificate for getting group D. I can show class 9.
No, class 9 certificate I can show.
Then what is the problem?
Class 9 certificate pass then.
Yes, suppose I show class 9 because you failed in Madhyamik. You were unsuccessful in Madhyamik.
Yes.
So you are, I don't know whether in class 9 you got pass marks in all the subjects, but you have been promoted to class 9.
I request your lordships, don't go on hypothetical basis.
Show us you are on this certificate of pass. You are giving, if what should I say? That is your
if your lordships, that was not issue. That's why this has not come up. If your lordship wants that, I have to produce. To clarify, to change your lordship's mind. That if your lordships want that.
Might have done so, but can it be ruled out in this manner that if I am promoted, people will start recognizing my certificate in which I obtain all marks.
All
pass mark in all the subjects.
That's your lordship, he has passed.
You are saying that, I'm not hypothetical. You are saying recruitment rule says a certificate of passing class 8. Here he has no certificate of.
I'm not asking for, I'm not on the nomenclature certificate. Certificate, progress report also. Progress report also.
You have not passed.
That's only thing.
So if I have not passed, but I am promoted, in class 9 also I have passed all the subjects.
Well, promoted, your lordship, that has to be shown promoted only, not on consideration. And with these marks, promoted means pass, my lord. পাগল নাকি শেষ করি নাকি দিয়ে গেছিল Malad, I am with your Justice Mitra. The simple word promoted means pass. But if it is with the addition on consideration, under consideration like this is not pass. Unless you show you have
an authority. Show us an authority.
Malad, your lordship is the authority.
Public.
But your lordship is the authority. Malad, this is the way, Malad, to be interpreted this sort of mark sheet.
No, this is the way entire West Bengal is going on. And you are now wanting us, you are taking away
because this was my first
taking away my bread.
No, my lord, I have lost my bread. I can show you lost the judgment.
You are 10 years junior.
Oh, my lord, 10 years junior. I have shown the illegal appointment. Supreme Court says you have enjoyed 12 years. Let him enjoy for 12 years. That judgment is also there.
We'll show you judgments where the court has not.
Now we are lost it because this was, my lord, kindly do not forget, this was my contention.
Sir, what is the evil intent? Kindly consider. Your argument we appreciate, but the thing is, why a person after having promotion will be have the wildest of thought that I will exercise this certificate to get a job in clerkate after 10 years.
I will. In the same school.
You were studying in same school.
Which same school? This is Bhupati Nagar. That is Bajkul. Not same school. One is Bajkul and other is Bhupati Nagar.
I will that my lord, my learned senior friends is vociferous in regard to that because of the reasoning. My lord, reasoning of the learned single judge. My lord, that can be substituted by your losses by other reasonings. Even if your losses do not accept that reasoning. I am only your losses on merit. If you don't, my lord, this is eligibility criteria at the threshold. And that's my argument, your losses. At the very first repetition, my lord, a person is, my lord, continuing fighting such a long.
You bring your first writ petition.
First writ petition, I will.
That's 29 page 30, which you are showing us. Page. আমি সম্পর্কে আরে পাস কাটু বলি তাহলেও কি আমার রিক্রুটমেন্ট গুলো আমার তো
তাকে বলে পাস তাকে বলে অনার্স সব জাজমেন্ট সুপ্রিম কোর্ট ডিফাইন করেছে অনার্স কাকে বলে
পাস করে গেলে ওটা কিন্তু চেঞ্জ হবে না এটা প্রমোটার আমি পড়াশোনাই করি
তো সেটাই বলছে বলছে ও দেখাতে পারবে শয়তান এটা তো এর কাছে নেই that is what he said.
Mr. Ghosh, the petitioner after class 8 did not pursue her education even though the transfer certificate says that she was reading in class 9.
Yes,
but there is no certificate of class 9 saying that she has passed.
Yes, that's true.
He left the education.
Should be from some other school. If you pass class 9,
might be, but here your losses, as my reading is that of the she left education at all, studying.
But in the precedence order, this what point which you are raising?
I will show you know everywhere this was. I will. My learned friend has taken your losses reading like him. I will take your losses reading like me, and then your losses will decide. I will show from each document. I am showing the directors of first order that this was my point.
যেটা ফাইনাল অর্ডার ছিল সেটার মধ্যে
বলুন,
অর্ডার পাস বাই দ্য জাস্টিস দত্ত দত্ত বলে যে ইকুইটি নেবেন হবে না
দেখুন এটা ফার্স্ট we have heard Mr. Mitra learned
Wait, but I am appearing in this writ petition. Sorry, appellants in this appeal, my lord. Appeal number, etc. will have given to my lord's officer, whom I am appearing for.
ওই পেপারটা বের কর একটা হচ্ছে ওই 875 আমার দিকে ওটা একটা নিচে একটা ওরকম করে দেখুক চারগুলো দিকে কত বলতে দেবে নাকি আর কি নাকি 200 টাকা কঠিয়ে দিয়েছে ভোট কালকে 200 টাকা কঠিয়ে দিয়েছে এটা অন্য গ্রুপের হয়েছে হ্যাঁ দলে দলে একটা কোন অ্যাপিলে অ্যাপিয়ার করছে ইনি কোন অ্যাপিলে করছে
নম্বরটা ঠিক আছে তো?
হ্যাঁ ওইটা আর আরেকটা
Yes. Yes. May it please, Lord Similor. I appear for 705 petitioners, 705 appellants.
in one appeal 1382
One appeal. Who are they?
705
705. Who are really a representative. There are 32,000 others of similar fate. Anyway, what is their case? Why they have appealed? They, in 2016, participated in selection process, along with the writ petitioners. 2017, they were successfully appointed. They are successful candidates and appointed and given the job. They started in employment since 2017. In September 2022, after 5 years, those unsuccessful candidates made this writ petition, 114 number, 139 effectively, for cancelling our appointments without impeding us. And I made a mistake.
There was no prayer for cancellation.
There is no prayer for our cancellation. They only asked for their appointments.
Yes.
Correct? Yes. They did not ask for, there is no prayer for our cancellation.
How many total persons were appointed?
Total was 72,000.
No,
32,000.
32,000. How many applicants were there?
32 untrained.
Among the writ petitioner, among the untrained candidates, how many posts were filled up by untrained candidates?
32,000 are not.
Total out of 32,000 total.
Please give us a sheet.
Plus
the total number of vacancies, total number of untrained candidates, total number of untrained candidates appointed. Please give us a, yes, you continue.
got 1,20,000
1,20,000.
and appointed
Look,
32,000.
this is specifically I have given in a note, give you that figure. I'm told you that round figure I'm giving, but specific broken figure I shall give you in writing, in note. 1,20,000 approximately, more than that, they participated. Out of that, untrained candidates for whom we are appearing in that group, 32,000 and odd. An appointment they received. Appointment 32,000 appointed? Yes. 32,000 untrained candidates were appointed, were successful.
Yes.
The writ petitioners did not ask for our cancellation. They came after 5 years, we are rendering service, we are in employment. After 5 years of continuous employment, writ petitioners filed their application for their own appointment. We have nothing to quarrel with them. We don't stand in the way. If there is, board can create posts and vacancies. Then, unexpectedly, that petition, without any formal amendment or anything, turned into something else.
No, Mr.
That-
Mitro, it has been argued before us what you have just
Yes.
now started.
No, don't repeat.
They were not made parties. There was no prayer for
No, that's right.
cancellation.
I'll
So
now
please argue any fresh
I
point you
followed.
want to argue.
I come to today my point.
Yes.
It has been argued before Lordship. There's an investigation. He was a investigation. Too much of an investigation by not befitting a judge. In this matter, not befitting a judge. Too much of investigation, not befitting a judge. That has been argued by Mr. Advocate General. So, don't rely on this order. It has been supplemented by Mr. Kollan Bandopadhyay by saying that this investigation, which is although not asked for in the petition, has been carried out without impeding, without notice to the parties sought to be affected.
And they did not get any chance to cross-examine.
Yes, I am adopting both. I am not repeating. I will add this submission now, that even in that unjustified investigation, without impeding the parties affected, no grounds have been found by the learned judge which can sustain his order for cancellation. Even upon that unwholesome investigation, without notice to the parties affected, learned judge has not been able to find any sustainable ground for cancellation of employment. So, Miller, kindly come straight to the judgment. I shall say on merit set aside this out. Not on this ground. Set on that is my addition. No. Now, kindly judgment, my lord. Kindly straight away from the judgment. It is volume 3 of Board's paper book. Board's paper book. And my lord, if I may straight away come to the judgment and straight away the paragraph 6. I take the ground one by one and request your lordship to see whether that ground can be sustained or not. Please come to me, Lord, paragraph 6 at page 6 and 13. That is the first ground. 6 and 13, volume 3.
Volume 3.
কোটে আছি কথা বলবো না কেটে দেবো So, there will be no repetition. I am on the merits of the judgment of the ground. Kindly come to paragraph 6. 6 and 7 to be taken together as the first ground.
Yes.
this court directed board to file one report as to the petitioner's breakup of total score about the TET examinations, 214, very important fact. Along with the breakup, some of
Yes.
Oh, pardon me. Pilot got it. Court directed the board to file a report of petitioner's breakup. Petitioner's breakup. Total score of TET 2014, along with the breakup score of last empaneled candidates in their respective medium category and district who participate in the requirement. So, district-wise, so the medium pass mark or what they call cut-off mark will vary from district to district, category to category. This is the judge is aware of that. This is a position. Now happened from that report. Now comes the first ground of the learned judge. From the said breakup, the petitioners found and alleged, where they alleged, anyway, that the particulars given therein are absolutely false, as because the lowest number of empaneled candidates was shown in the report as 14.191. Kindly take note. 14 marks, 1.9, lowest. Whereas throughout West Bengal, 824 candidates who scored below 13 were appointed. And the petitioners prepared a tabular sheet to that effect and enclosed in annexure, etc. This is page 21. What you find that. What is
Where
that?
is that
Where
report?
from?
11th of January 23, which page?
Page below. I'm giving the page. It is in the
Page 14 of compilation.
there's a compilation file.
Yes, we have the compilation. Give us the page number.
I'm told there's a compilation file by Mr. Lahiri.
Affidavit in opposition.
Huh?
Affidavit in opposition.
I'm separate it.
Which?
It's been prepared from the affidavit in opposition filed by the writ petitioners.
Please give us the page number because we have gone through the
Paragraph.
compilation, which has been annexed, page 700 and that.
Yes.
Compilation is from pages 123 to 237.
This part is not in that compilation.
This compilation was in first matter.
This was filed in respect of stay petition of the board by the writ petitioners. There, this notification is there.
Stay petition?
Opposition to the stay on behalf of the writ petitioner. There they have annexed.
What is the page number of your?
Of that stay petition.
That is 1352. Your paper book.
No, this is this is not in the paper book of the board also, but this is on the record. This was filed by the writ petitioners.
When filed?
Give us the compilation, Mr. Dev. So you are meaning to say that the compilation given in 873 is a different one? 873 appeal.
Yes, compilation is different.
Different. So that is not with us. You have not annexed in the paper book.
That is in respect of the board's appeal.
We are not concerned with
compilation for your lordship. Copy you have.
So how many compilations we shall rely? Because it was started saying that there is one compilation which has been annexed from page 123 of the.
Compilation. This is the affidavit in opposition on behalf of the writ
So
petitioner.
there must be common pages in that, na? It was your duty to segregate that. Please do not expect us to go 800 pages document as and when you will pick it up. Forget about board, Mr. Devbarman. It is your child. You will not tell us that this is the compilation report in the paper book. Whose appeal is it?
Appeal of board.
This appeal, you are the 705 appellants are here. So where do you have annexed that compilation?
That appeal, you are not hard to call this thing, you have procure somehow subsequently.
So tell us how many compilations are there we have to go through. What is the compilation of yours? Please write down in bold letters that this is pertaining to this appeal. and show us the Mr. Mitra is referring to the board's report. You bring out that board's report. 11th of January 2023. Yes, Mr. Mitra, you proceed.
Let me make submission. I shall then try to get it in one. Whatever documents are convenient should be in one compilation. That will be convenient. Doctor cannot have to shuffle from it.
That is what we were saying from the very beginning.
Let me see what we can say. I can say relevant,
Yes,
then I make it. The question is where from the learned judge got this lowest mark of 14.191. Where from? That they got. They got
ওটাতে
from the
appeal নাম্বারটা লেখো।
এই ফ্ল্যাগ করা আছে কি কি মার্কটা করা নেই তো মার্ক করা নেই তো না না মার্ক করা কপি দেবে কিরকম করে এটা আমাকে হ্যাঁ এটা আমাকে না না মার্ক করা কপি দিন এমনি এটা দিন ওটা আমাকে দিন ওটা আমাকে
এটাতে কিশোর দত্ত
that portion relying upon, we make a separate compilation. Let us see.
No further compilation.
No
Mr.
further.
Mitra, you point out what you have to point out from it.
Enough for paper industry, not more. But 14.191
Yes.
we have got. They
So,
got it.
are you meaning that this is false recording?
No,
14.191 is
No, it is correct.
It is
correct.
yes.
But in respect of what? In respect of Birbhum district.
Only
Birbhum district and scheduled caste. (141) is not the lowest mark for all category, all districts. There are 20 districts. And court has selected as 14.1 district Birbhum without mentioning in his judgment.
SC.
District Birbhum, I show from that.
No, Birbhum district scheduled
District
caste.
Birbhum.
Scheduled caste candidates.
Scheduled caste category. Yeah. And this list was supplied to court by the writ petitioners on 11th of January 2023. Judgment delivered in May 2023. And this is a bit. Now, please take this. See the forwarding letter. Page 14.
No, we didn't understand.
Of
We
this
didn't.
is the
board has given a breakup of marks of the paragraph 6 which you placed.
board has given a breakup cut
of
marks of all district all petitioners.
The judge says that the lowest mark obtained by an impanel candidate was 14.19. However, I find that 824 candidates having less than 14.19
Yes.
had been given up.
Now 14 point is this correct statement to make? Question is 14.191 was it lowest mark for all the candidates in all 20 districts?
Show us this 824 does not belong to
Yes, that's what I'm trying to show. This document, this chart which was submitted was disclosed. How we came to know of it? It was disclosed much later in the affidavit affirmed by the writ petitioners on 28th August 2023. In opposition. This chart was given to court in January 2023.
Yes, January 23. Yes.
See that? Come to page 14. An affidavit affirmation date, page 13. It is 20th August 2023. That's after judgment. after judgment of the court. In this appeal, they disclosed during the stay proceedings. The writ petitioner disclosed.
Where from you are getting the date of 24th August?
This is, come to page 14, kindly come to page 14.
Page 14 of? Page 14 of what?
The affidavit in opposition.
I don't know. We have not got the copies.
It was dated.
Which page you are saying?
This is. বলুন পাচ্ছেন রসিক affidavit নেই বলছে কোথা আছে বলুন তো Rosik got the affidavit in opposition and make him a copy. Rosik copy না দিলে কেউ কি জজ জানবেন?
You 705 appellants are from which district?
This is
which district you belong to? 705 appellants? আরে কিছুই বার করে আছে আমরা মুখছি আমাদের
different district, different cut-off mark, different district. May I only pay first? For my argument, now I'm showing you 14.191 was the cut-off mark of Birbhum district. And how do I get it? Please take this document as page 14. This affidavit, annexure to the affidavit opposition of the writ petitioners themselves. Because they had submitted this, primary education submitted this, and they knew.
Page 14.
Yes, page 14. West Bengal Board of Primary Education submitting to the council for the board, supplying to the council. This was submitted to court. The 14.19 কোন পেজে আছে বলছো? Yes. Now please come, my lord, to page 20. Please come to page 20. The list heading, list of breakup of. Please come to 20. The list of breakup of total score of the last impaneled candidates in cross mark is given. This is in their respective medium category and the district. Page 20, this is coming. Please come to page 21. And last but one item. They have given me lot Bengali, then etc. And then Nia Das. This is number is given. It is for Birbhum district. Item number, serial number 19. Got it. Item number, page 21, serial number 19.
Yes.
This is Birbhum district. This is serial number 19, Birbhum district. That is it is. This is the minimum, this is the list of cut-off marks of all the 20 districts. Kindly come back to page 20, heading, the list of breakup of total score of the last impaneled candidate, that is the lowest mark, in the respective medium and district. But these are serial number is given, starting from 3 in one district. I can tell you all 3 minutes. You get it from page 21, 28. This serial number 19 starts for, it means Birbhum district.
Where from we will get?
Yes, where from get it? Notification issued by West Bengal Board of Primary Education.
Okay.
Notification for application forms for TET 2014.
Where are you reading?
I am reading from a compilation prepared by Mr. Lahiri. Mr. Lahiri.
Mr. Lahiri. He is in which app? Then what is this?
pay application in this application. They are documented.
Mr. Mitro, are you relying upon this compilation or something?
Yes, the combination not only to indicate 19 means which district. Lakshmi has seen page 20.
21.
20 starts from serial number 3, 4, etc. 3 stands for one district. I can give you the number from here. Is some district. 4 is for another district. Serial number stands for another district. And if you also take it from me,
This is serial number 19 is
19 stands for Birbhum district.
Very good.
And this is all given. Kindly come to compilation. Yes. This is in the state in notification given. Darjeeling is number 1 serial. Serial number 01.
This notification is pertaining to 1873. This
ওইটা
compilation.
কি কিসের
You were saying you are for MAT 1352.
দেখো
So this is another MAT number which is given. Sir, please tell completely that this is what we have done, not in installment. We are not concerned. Then
Not following that, the same document is there in page 86 of the paper. Same document.
paper book
are you appearing in MAT 1352?
Yes, but I am
Huh? You are also in 1352. Any other council is there in 1352? Because tomorrow he will come and say, I am relying upon this compilation.
I have prepared this, so therefore I am saying.
86 page 86 what এটা কিসের এটা বোর্ডের এটা অন্য জিনিস
বুঝতে পারছো?
এটা কি বোর্ডের এটা তাই কেন তুমি দিচ্ছ তাহলে this will appear also from the paper book of board volume 1. Make a note of that volume 1 of board paper book page 86. কেন কম্বিনেশন দিচ্ছ বলাচ্ছ কেন পরিষ্কার এখানে আছে তো notification for application forms for TET 2041 and lordship below that district-wide list of UBI branches, DPSC, chamber of distribution, etc. Darjeeling starts number 101. The serial number, district with code. On the heading, district with code. District Darjeeling 01. Lordship may rely on the council that when they're saying serial number 19 refers to Birbhum, on the other side, if they dispute, then also
We are not disputing.
yes, then not kindly come to this one without referring to anything. It is serial number 14.191.
Yes.
From here, the learned judge getting the lowest mark.
Yes.
But in the judgment, he doesn't say it is for Birbhum district.
Yes.
Also, it is not stated that out of 140 writ petitioners, there are 3 candidates from Birbhum district who are not successful. Did they obtain more than 14.191? Then matter would am I clear? District lowest pass mark for Birbhum district is 14.191. There are 3 writ petitioners of Birbhum. If they had obtained more than 14 marks and yet were declared unsuccessful, then Miller, that will be ground. Now, my lord, if there are
Which are those three petitioners and what is
lead
the
petitioners, and there are 3 lead petitioners who
three lead
number, give
petitioners?
me the number,
Yes.
119, 119, 132, and only 53. 53.
53.
53.
53, 119 and 132.
Yes. Please come to me, Lord, page 19 now. And what number they got, I'm giving you Lordship, then Lordship verify it from the record for convenience. Number, petition number 119 got 12.85.
Who got?
12.85.
53 got.
Petition number 119.
First give us 53.
Yes. Oh, first says 53. The 53 got 11.442.
What is the name of 53?
নামটা বলে দাও।
Safikul Alam. Safikul Alam.
Safikul. Yes, how much did he get?
Then next is
how much did he get? Safikul.
119 I have given. Next number? 11.442.
All right.
So below 14.
Then 119?
And he got 12.85.
Name?
12.85. Name? Gourango. Okay. Bine. Bine.
And
Bine.
And 132.
And then 132, 12.644, no? 644.
Only
12.644. And where from I get this?
What is his name?
For that Lordship kindly turn to.
Noor Huda Khan.
And Lordship will get that from page 20. What are 20? Page? Page 9, sorry, page 19. Page 19.
Page 19 of what?
Of this same document.
Affidavit.
Same annexure.
Are you relying upon this?
No, that is
No.
compilation. Affidavit of Soil.
Remove, please, remove the compilation now. I am now referring to compilation now. I am referring to page 21 of the annexure to the affidavit in opposition of the lead petitioners filed in a state proceeding. And what is that? Is a list of candidates and what cut-off marks, what the minimum marks they obtained for different districts.
Yes.
Milord, if now turn to page 19, it begins much earlier. It begins from page
14.
That is, Milord.
Show us 19. Show us 19.
And here, Milord, kindly come to serial number. Last page 19, 19, 20, 19, 20, 19. The key number to put the machine. 19 district code. T 19, 19, 19. There are 3 Birbhum candidates in the distribution, 1919. And the name is given Gourango Bine, 12.855. Noor Huda Khan, 12.864. And Safikul Alam, 1144.
Yes. Only Gourango is relevant. Because Gourango is SC.
Gourango Bine, he got
SC. The other
12 point.
Your argument was that this cutoff which has been given, this is in respect of Birbhum schedule caste only.
Birbhum.
So you, after the 3 examples which you have given just now, out of which only one is SC, others are not of that category. That you have not pointed out.
Oh, this is SC only one.
Only SC.
And others
So
are
your
OBCA,
argument ought to have been
others are OBCA, OBCA.
that we are not concerned because 14.141 does not tally to OBC.
Very good. Very good. Then this is Bengali SC. Yes, you are
All right,
SC.
you proceed with the judgment now, Mr. Mitra.
Right. Therefore, my
So
lord,
your argument is only one discrepancy you have shown us in respect of Gaurang.
therefore,
Yes.
my lord, the only one, this petitioner of SC from Birbhum, he got 12 point.
We understood that had he got more than 14, then the question would have come.
No, this was before the court. This chart was before the court in January one time. Then, if the court, in spite of this, makes this finding, what would you call it? If
because nobody pointed it out to the court. All were silent spectators. Nobody, there is no argument that this is wrong.
None of us
What
were
is wrong?
present.
Just a moment.
None of us were
No,
present.
The argument which you are
what
advancing.
is wrong? The judgment is wrong, not the chart. What the part people will show? When the matter is being argued,
yes,
they would not know what judgment will be
that
filed.
is your
in the court.
argument. Show us from the affidavit that this point was taken.
The point, nobody has.
You have no locus to say that. This is on the basis of the records of writ petition. You are the appellants before us now.
Yes, yes.
Have you filed any pleadings? You had no scope to use any pleadings in that writ petition.
Correct, correct.
So you
Absolutely
show
correct.
us that this point was taken by the respondents in their affidavit in opposition.
Now, what point could be taken? What point? What is the point?
Mr. Mitra, kindly concise yourself to the actual challenge.
My lord,
Don't
my lord,
take us for it.
kindly.
You are taking us on the basis of this, that there was no pleading, nothing was said, advocates were silent, court on itself arrived at this corner. This is your argument. Yes.
Court arrived at this as the final judgment from a report submitted to him by the board as per his direction. And from that report, court found that 14 was the lowest mark for Birdum SC. Let us read. Now, in the judgment, what the court will say, nobody would know.
I think we are not clear to you. We have asked you that this argument which you are advancing before us, was there any glimpse of such pleading in the records before the writ court? If this is taken
We are not
up,
parties. We are not parties.
not of you. We are not saying you. We are saying about the board and the board in the writ petition. Board has never said this. That what, my lord, you are referring, this is a wrong statement you are recording.
One mistake. Kindly, will
So
permit me.
all right, Mr. Mitra,
No,
you
Lordship noted.
proceed.
Lordship making with respect one mistake. The mistake of the judge is appearing in the judgment. How the board will know that this mistake will be committed by the judgment in the judgment when the argument was going on?
No. Was it not incumbent upon the board to tell to the court the argument which you are advancing?
No.
14
Kindly allow me. Kindly can listen to it. This, that the board, that court will file a judgment as a ground saying that the total lowest mark was 14 point such and such. And the writ petitioner has scored more than or near that, and some can how would the board know? Was this point indicated? Judgment was given, dictated in court, and then argument started. Argument starts after judgment. How would the board know? Anybody would know that the judge will make it a ground when it is not in the pleading? Please consider from that angle. I am asserting the judgment.
50,
on the basis
50 occasions the writ petition was heard.
Writ petition was hard.
And this exception was filed on 11 January.
In the writ petition, is it anywhere stated that 14.191 was the overall lowest mark? Not stated anywhere.
That has come on record on 11th of January. That is from the report. Serial number 19. Yes, Mr. Mitra.
May I just humbly summarize what I'm saying? In the judgment, court has given a new ground for cancellation of appointment. The new ground is that district-wise, lowest pass mark was 14.191. And although there were candidates who have scored more, they were ignored. This point, if not taken a writ petition, one would not know how to deal with that. It is nowhere on record the judge, honorable judge, in course of hearing, disclosed to the parties, appearing parties, that this point is troubling me, as normally fair judges do. This point is troubling me. I find that district-wise lowest pass mark was 14, and so many petitioners got more than that. If the question was put, the learned judge, learned counsel, appellate board would have the occasion to say, would have the opportunity to say, the lawsuit, we are making a mistake. 14 is not the benchmark for the entire candidates. It is only the benchmark for one district, Birbhum scheduled caste. And kindly see, has any of the petitioners got more than that? Any of the petitioners belonging to Birbhum SC has got more than that.
Only one person was there. Only one person was there.
Only one person did petitioners. So, Miller, he had below this. No? Yeah. Now, let us take one by one. Therefore, this reasoning given by the learned judge in the judgment is factually incorrect. And learned judge, if I put most humbly, he has misdirected himself. On that basis, learned judge what say? 824 candidates who scored below 13 were appointed. Very good. But in which districts were they appointed in the category of scheduled caste in the Birbhum? Doesn't say.
Yes.
Now, am I clear, Miller? Why this question could not be answered? Why this question could not be anticipated by the board? This is for the board to say. A point can be anticipated which is in the pleading, number one, or sometime when they discuss in court. But there is nobody's case these are discussed in court. The learned judge opened up his mind and said, I'm going to consider this as if this point is troubling me, as my lord very often say. This point is troubling me, although may not be in the pleading, but tell me what you have got to say. কোথায় বলছি?
This is exception to the writ petition. Includes is an
But I get more instances of it out of the book.
exception to the report file. Exception to the petition.
এটা কোন পেজ নেই?
এটা কিছুই আছে। পঞ্চাশবার জিনিসটা হয় শুধু একটা স্টেটমেন্ট
এটা কি 24 জানুয়ারি কি অ্যাফিডেভিট এক্সেপশন দিয়েছিল?
Yes.
So, well, this is a totally wrong finding. 824 candidates, it was not the.
That was of all over the district,
Hello?
all over the state.
All over the districts. Now, my lord, I can give you more examples of this. You will kindly come to page 19.
Not required, Mr.
Yeah, more, totally more. Different district, what is the lowest mark pass off, and none of the petitioners got more than that. None of the petitioners got any of the districts. It has placed district-wise lowest mark, lowest pass mark.
That is because there was favoritism, there was a scam. That is why you opted it, even though
Yes.
you did not come.
Scam is where?
Scam is where?
Scam is where?
It is explicit from the
My lord.
records. Have you seen this document?
Scam where?
We are showing it to you.
Kindly, I will
Come to
get
page 237. Page 237.
237 of the volume
Of MAT 873.
But a volume 1. Volume 1. Kindly. Oh, I'm grateful to my lord for this is my lord, what you expect. The court will open up. No, এখানে আছে তো যাও আমারটা তো এখানে আছে yes RTI report against 42,949 vacancies. Yes, madam.
Have you considered this?
No, I have not. Doctor, can you say?
Then we will put question to the board because this is not your document.
May I point out? How many know what is the point?
No, we will put the question to the board. You place your case, Mr.
This is the primary teacher recruitment.
You had one paragraph 7.
Paragraph 7.
Yes. Next, what is your point?
Very well. I'll take note of this and study it in the evening. Yes. This is ground number 1. 824 candidates scored below 13. They got it. Totally wrong. Totally wrong. Now see the first ground. Get to go. Now see the next ground. Next ground, paragraph 8. Next reasoning, paragraph 8. From the pleading of the petitioners, it is found that they wanted marks of last empaneled candidates of different categories like SC, OBC, etc. But no such particulars were supplied and produced by the board, despite direction given by this court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioner as well as from the court. This is the next comment. From the pleadings, there's the prayer B2, there's the order, there's a prayer for that the give the different categories, etc. Empanel candidates, give the detailed marks. They wanted the marks. This is Milord prayer BII of the writ petition. I'm reading out the prayer. Doctor need not prayer. Volume আমি তো দেখছি এখন this is volume 1. Let's find this reading. Let's don't page 47, 48. E2 to direct the authorities to file a report disclosing page 47 below. This is page 47, volume 1, page 47. This is the final order they're asking for. Rule editor B, prayer B, editor mandamus issued directing the respondent to act in accordance with law. Then 2, to direct the authorities to file a report disclosing names, a number, rank, the category of all non-trained candidates who have been recruited till date in primary school from state to very, very wide prayer, final order they're asking for.
Yes.
But no such particulars appeared. It was when if the court makes a final order, then question of board supplying these particulars arise. Now kindly come back to the judgment, my lord. A decree is passed, let us say, for possession of property. And with the possession given before judgment is delivered. This is the final order, they are asking for some direction. Very good. Let us see, it is being allowed. What is the point? But no such particular supplied produced by the board, despite direction given by this court. When the direction was given? When?
Yes.
When the direction was given? Judge does not mention any date of giving such direction. In opposition of the board maintain silence. Opposition to the prayer, which is kindly, Miller, consider this. A prayer is made in the main writ petition. In the opposition court is supposed to be fulfill those prayers. Opposition will say, yes, prayer to final prayer is to direction upon us to, therefore I shall give the report particularly now in opposition. Is the ratio of this judgment. Is that the law? That's what my lord is complaining here. The prayer was made, prayer B, and in opposition you allow the prayer. What is it?
Kindly come to paragraph 10 of the
I come to paragraph 10, will certainly. Paragraph 10 I'll come to. Then
what was their case? Their case was.
Prayer?
What was their case? Writ petitioner's
Yes,
case.
yes.
You are saying that there is no pleading, only by court.
Paragraph 2. Lordship, paragraph
9.
2. Yeah, Lordship, 1 minute to
Paragraph 9
paragraph 9 of the judgment.
of the writ petition.
Writ petition. No, writ petition.
Now, let us understand. Your
Yes,
argument
yes,
is there was no pleading.
No.
There was no pleading.
No, I have not said that.
Because
there's a prayer made.
Uh-huh.
I'm saying
You are saying that only what has been said in the prayer, the judge has quoted that and has recorded in paragraph 8.
No, I said that the prayer was made in the petition for such particulars. And judge is saying in the affidavit in opposition, why have you not given those particulars in compliance with the final prayer made in the petition? Please see what judge has said and please confine yourself to what the judgment says. Please see, my lord. From the pleadings of the petitioner. Suppose the pleading is made a particular required. In opposition, we should give the particulars. Is it the system of our judiciary? A person in the petition asks for petition, the plaintiff should give the particulars. Here in paragraph 2 of the petition, and prayer is made in the final prayer. In opposition, you shall supply the particulars. That's the complaint of the judge. See the total, what to say, absurdity of this reasoning. See, what is given. But if the court give a direction, certainly give. Interim direction, court give. Therefore, can you see what direction was given by the court when and what was done thereafter. Reason given by the judge doesn't stand scrutiny. In the petition, in the plaint, a lot of particulars may be asked for. Prayer may be asked for petition. But in written statement of the opposition, you don't give the particulars. There is no obligation to do so. And that's what if I read. But no such particulars supplied and produced by the board, despite direction by the court. Then I can understand direction given, not that. In affidavit opposition, board maintain silent in the regard. What they say, affidavit opposition? Yes, yes, these prayers are made. Yes, yes, I fulfill the prayers, allow the prayer, affidavit opposition. The board maintains silence about the prayers. What's wrong there? Please consider. If the pleading is made asking for some particulars, and the specific prayer is made, final prayer is made in the petition, and in opposition, those prayers are not to be complied with. Yes, my lord.
In the writ petition, what was the case of the petitioners?
Case of?
The writ petitioners.
Hmm.
Case of the writ petitioners was that there was a recruitment process in which no panel was published, no merit list was there.
Yes.
Appointments were made beyond the vacancies notified in the advertisement. As such, we are making a prayer to the court that my lord kindly ask them to disclose what marks the respective candidates have obtained.
Correct. Absolutely. Justified prayer. In the
Your
final,
argument,
yes,
so
that
your
was just-
argument was you are running the case of the board. You are saying just because such an awardment has been made, where is the court's direction that board becomes obligatory on their part to disclose the marks? Can you?
I'm sorry, I have not made myself clear. Because judgment says, judgment is taking a apron that what the board did not do. In the affidavit in opposition of the board, maintain silence in this regard. What they're supposed to say, board in the opposition, that these are the
They would
players.
say that the marks that they would say that the panel was published, the merit list was disclosed. This was the mark obtained. That is what we think it was incumbent upon the board to do.
Therefore, in the affidavit of opposition, because some particulars
Have not been given.
that they wanted marks of last impanel candidates.
Yes.
And the board will disclose that in affidavit of opposition, or wait till the court gives a direction to that effect.
Anyway, that is your argument. All right, you proceed further.
Proceed further. That in the because the prayer is made, affidavit of opposition is filed to deal with the prayers. Sometimes the prayer should not be granted, should be dismissed. But affidavit of opposition is not filed to fulfill the prayers at the stage of affidavit of opposition. At the final hearing, court may give interim direction, court may give final direction, then we're bound to follow that, sub-particulars.
So your argument is there was no obligation on the part of the board to answer to the prayer of
in affidavit of opposition.
Very good. Very good.
In affidavit of opposition, to Answer, no, answer is there.
this
No,
was
no,
not
answer,
the
no. Answer certainly there. But to comply with the prayers made in the petition, there is no obligation to comply with the prayers in the opposition. There is no obligation on the part of any opponent to comply with to allow the prayers for particulars in opposition.
Yes.
But they deal with that allegation. Board may say, opponent may say, no, there's particulars not uncalled for or something, whatever. Or they may, yes, we shall give particulars whenever court directs, whatever they say.
This
But
was not the
absence-
argument of board. What you are arguing, this was not the argument of the
May not be. If the board has not done it, I shall make it up. I shall make as I'm appellant.
Yes.
I am to answer all the grounds made by the judge.
Yes.
And I was not made a party, that's why I could not give that answer. If the answer was there, and in spite of that, the respondent did not give the answer, the time appeal is the stage at which non-appealing parties will give that answer. If the appealing party did not fail to give the answer which they should have given or could have given, the non-appearing parties at the appellate stage will fill up that lacuna.
How will you know how many marks was obtained by this 1,20,000 candidates?
Yes,
Is it
if
possible
they're
for you-
relevant, no.
What relevant? Is it possible for you to disclose?
No,
You are a mere participant in this recruitment process.
Not-
Anyway, Mr. Mitra, we proceed.
If
We
it's
have
not
taken note
possible,
of your
but ends
ground.
there. Found a wanted marks of last empanel
Yes,
candidate.
next, what is your argument?
No, come to the next ground. In this paragraph, we'll say the main point we're missing. And that's why direction given by the court. If the court has given interim direction, they're bound to give the particulars. Therefore, Lordship may ask me, the court has not mentioned, judgment does not mention any direction dated such and such. There may be omission on the part of the judgment and a part of the court. But court may ask me why they should given or not. I shall tell you, Lordship, yes, directions were given. That is the question we're expecting from the bench. Not that in opinion of opposition, why didn't give the particulars.
So we cannot question you.
My lord.
We cannot ask questions to you.
That's why I'm saying, my lord.
Saying that court is asking this thing. We want to clear our doubts. We cannot put questions to
And
you.
I am also entitled to say that this question is not relevant, and this question is relevant. They have to answer.
So your argument is it is not a relevant question. I will not answer.
No. I have answered the question by saying that there is no question of the giving the particulars men in the main prayers at the affidavit in opposition.
All right. We
That's
have
what I've said.
said. All right.
And
We
that's
have-
why this question, Lordship may ask me, what direction was given? That direction was given by the court.
So you
Interim
leave it up
direction.
to us what questions we are to put to you. Please leave it up to us. We thought that this should be the question put. That's why we
Very
put
good,
the
very
question.
good.
Yes.
But if my lord thinks many questions relevant, and if a council is a bench asks question, a bar obligation is also there to show, yes, ma'am, this question you're raising, but this question is not relevant.
All
I
right,
didn't
all
say
right.
that. That
All
is
right,
showing a disrespect to court. I'm pointing out, I'm here to answer the questions. I can answer the question, say, by saying this question doesn't arise. I can answer the question. There's
Yes.
nothing to affront the court. But now, Miller, come to the main thing. Despite direction given by this court, direction was given by the court. I'm going to show Your Lordship that.
Yes.
And direction was complied with or not. That's the question. That's the direction of the court. The direction for supply was given on December 20, 2022 by an order of that date. Lordship will find that at page 418, volume 2 of the brief of documents, paper book of both. Yes. Relevant portion is at 419. Order is at page 418. Relevant portion 419, last paragraph. Can you? I am supplying this lacuna in the judgment. Direction was given by the court. Then see whether that was complied with or not. Last paragraph, page 419. Mr. Bishas also directed. Mr. Bishas appearing for the board is also directed to come up with particulars in tabular form of the marks obtained by last employed candidates of different categories and different medium of all districts on 10th January 2023. I have got it, Miller. Page. Compilation is the board here. Put it repeatedly.
Yes.
Now, how far they complied with? This is the question. Now, Miller, compilation just given. A compilation which has been handed over to your lordship. I got it, Miller. Kindly come to page 119 of this compilation, Miller. Give a little again. Convenient. Candidates based on district, opted medium caste, etc. by two-turn recruitment process in compliance order passed by Honorable Justice Abhijit Gangopadhyay in writ petition number first one in which the judgment is delivered. It order passed in 5 writ petitions are hereby published in WP in the following website, etc.
এখানে আমি লিখলাম no detection was given.
No. A judgment was delivered in in 5 different writ petitions, this order was passed and board has published that. This order is not passed in this writ petition. This writ petition in a judgment is delivered is number WPA 21187 of 2022. Please, Miller, see. Very good. There you can turn the page, also find 120 onwards, the of district, etc. Last impanel untrained candidates. 1200 pages of this particular is given. 1200 pages.
Pertaining to the said writ petitions.
Hello. In pursuant order passed in similar maybe 5 other writ petitions. It was given by this. On the, that I find pressing a lordship. a deficiency and all that I'm placing your lordship. So, there has been no suppression. I am now meeting the judges, London judges' point. Therefore, there has been suppression by the board. Paragraph 8 can we come to underline by the London judges. This is nothing but suppression of facts from the petitioner as well as from the court. This conclusion I am only pointing out is not correct, and nothing more, nothing less. That is my answer to the question of suppression as held to be a ground by the learned judge. Milord, can I come to next ground? I may come to next ground, Milord. Paragraph 9. That is a very serious ground. Aptitude test, no such test taken, according to learned judge. This is not very important ground. Please, Milord. Paragraph 9. In respect of holding an aptitude test, chairman of the board in his report said aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. In this regard, order passed by this court on 6 February 2023, not challenged till now, is pursuant order passed on 6 February, following named teachers who took interview of some of the candidates, recruitment process for teachers of primary school is conducted by West Bengal board, etc., were taken up. The real question was whether aptitude tests of candidates were taken or not. From the table below, the reply to the test would be found. The next question, no aptitude test taken. This is the next point. Now, this point is not taken in a writ petition. That do not say, the petitioner do not say in the writ petition that no aptitude test was taken. Yeah. Because that appeared in aptitude test and got some marks against aptitude test. Well, let us see, but court may entering into roving inspection, as Advocate General put it, in roving inspection. Similar to why the court will go into that question. Will the court making a new case? No aptitude test taken. Then, now the basis of this finding is the oral evidence. Of interviewer and candidate.
Yes.
Not anything in the pleading or the affidavit of the parties. Court has not referred to any pleading or statement in affidavits filed by the parties in the proceeding by both parties to hold that no aptitude test was taken. It is similar how the court is coming to the conclusion. Pursuant to order 6 February 23. Can you check order page 6 February 2023? Evidence is being taken. But before that, there is an order when court decide to make examination. Please come to me, Lord. First order, I'm placing chronologically. 17 January 2023, page 421, volume 11, volume 2 of the board paper book. Not one.
That's it. Of board's appeal.
Board's affidavit, board's paper book. The volume 2 to read, আমার 11 লেখা আছে তো। ও আই বড় আই করি। This order similar how 17 January.
Yes.
Page 421. In course of hearing,
That has been quoted, na?
421.
That
volume
portion has been quoted in paragraph 9. That portion which you are placing has been quoted in the
in the board's paper book.
That has been quoted in the judgment which you are showing.
No, this order is not referred to in the judgment.
Isn't it?
Order referred to
6th February. 17th January. You are referring to 17th January.
No, I'm 17 January 2023.
Yes.
17 January 2023. When this court decide to examine on oral evidence, this is not referred to in the judgment. Judgment refers to a later order, 6th February.
Yes.
I am showing you also a prior order
Here.
where court decides. And the ground disclosed by the court why the examination will be done. Oral. 421.
Yes.
In course of, my lord, got it? May I place it now? In course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, only interview was taken and there is no aptitude test, though in the aptitude test there are 5 marks. 5 marks are there also for interview. Similar oral submissions made by the petitioner that interview was made but no aptitude test. Please refer to page 418 of this same volume, my lord. 418. An order dated 2012-2022. I have heard extensively the parties in the matter. The case of the petitioners, in short, is that though the petitioners got higher marks before addition of marks against the interview and aptitude test, comparing to some candidates who have been given appointments against 2016 recruitment process, even after adding their marks or personality test and aptitude, they have not been given appointment. This is the argument they're making. They have come before the court as has been submitted after taking inspection from the records produced before the Honorable Chief Justice Court in a PIL. And they have also got some inputs from publication of the marks of the M-panel candidates. So this is argument, this is how the matter starts. Then after, in that context, the direction of page 419, Mr. Board Director gave direction, a matter again. Then next order passed, I'm showing to Lordship that order which was passed in 421. I placed that order, total marks asking for. Their admitting interview was taken But aptitude test, if there are tests, though aptitude test, there are 5 marks out of 50, 5 marks are for aptitude test, and this oral submission was made on this date. That no. Next, as a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165 of Indian Evidence Act. This is the origin of the order, not 6 February. The order for oral examination is dated 17 January 2023, not 6 February. People must come later. And I asked 7 of the and I asked some questions after administering oath to 7. The question on examination chief was taken on 17 February. Evidence was taken. Volume 3 doctor. This is the order, and on this very date, examination take place. On what basis? I decided to exercise my power under 165, and I asked some questions after administering oath to 7 of such candidates. How the 7 was selected? Out of 140, court on the spot selected 7, and they are all present in courtroom. 7 writ petitioners who will be cross-examined was present in courtroom 17 January 2023, although there is the previous order that there will be oral examination of any of the writ petitioners. This fact remains. Next, consider this on the point. On what basis these 7 petitioners selected? 1, 4, 7, etc.
Yes.
Now, Lord will find who are in evidence out of 140 petitioners, 7 petitioners who got the lowest mark in aptitude test, 2 and something, they were selected. And how the judge knew? Judge knew what on the date of on January 17, who got the lowest marks. Please come to me, Lord. This is that I've shown to you, Lordship, in opposition, Milord. That paragraph, page 14.
Yes.
I'll request your Lordship, see the examination done by the court.
All right, we take it. They got the lowest in aptitude.
My lord.
They got those 7 persons got lowest in aptitude.
And judge knew that. Then judge chose those 7 persons who got the lowest mark among the 140 writ petitioners for evidence. There are several writ petitioners who got 9, 10 full mark in their aptitude test. They were not called. These marks will, that is now all record. And it was known to the judge that this petitioner got the highest mark, full mark. They were not being called. They are not being selected. So the next grievance of mine is, on what basis the selection was made to make oral examination of only 7 out of 140?
Yes, that has been argued by Mr. Dutt.
That is on the basis
that this argument was advanced by Mr. Dutt.
There are petitioners who got full marks. They'll all get in the chart. Who got in it? Now let's see the evidence now. Would Lordship find volume 3? And sorry, let me complete the order, then I come to it. He took the oral evidence. From their evidence, I am satisfied that there was no aptitude test. That is the only basis for the order or conclusion.
Where are you reading?
Continuation of that page, 422. Next page of that order. So their oral evidence of 7 writ petitioners was the only basis for the writ court holding that there is no aptitude test. Now, do the oral evidence lead to that conclusion? In my humble submission, do not. Now, see the oral evidence. Page 483, volume 3 of board's paper book. Volume 3, take that. This is in volume 3, first page.
Total নিয়েছে
It starts at 494. Oh, sorry, I made a mistake. 489. 489. 489. 489. The petition is argument to Mr. Selim Ali.
No, Mr. Mitra, kindly come to page 422.
422. Yes, my lord. A 14 order is
421. You showed us
yes,
7
422
persons.
is the basis order is passed.
7 persons.
Yes.
And you said that
From
only
this
on the
evidence, I am
basis of
satisfied there
7
is no
persons.
aptitude test.
Sir, kindly come to 423.
423.
Page 423.
423, my lord. Yes, my lord. I directed petitioners that at least 2 candidates from each district are to be present before this court.
So it was not restricted to those 7.
No.
Now kindly come to the next page. Next page.
That is the next day, 24/1.
But ultimately 119 candidates deposed.
Yes, 140 petitioners. Examination takes place on 17. And Lordship is now referring to order dated 24th, 7 days thereafter.
24.
Hmm?
19 এটাতে
কাতে?
আরো ক্যান্ডিডেট হয়েছিল on 17 January there were 7 persons.
That is second batch of maybe. I am on the seven it means
Your argument is on the basis of 7 persons evidence who secured the lowest in aptitude. The court arrived at a finding that there was no aptitude.
yes, that's
This
good.
is
Now
your argument.
yes. To that minute I humbly place the evidence of very short evidence of those selected 4 persons, and my submission would be that evidence do not lead to a reasonable conclusion that no aptitude test was taken. 489 Milok.
But ultimately 26 persons evidence was taken. This you
For 96.
19 plus this 7.
Yes, subsequently 19%. I'll deal with that. I'll go by stages, Milok. Go by stages. By having heard the evidence of seven, judge was satisfied. Is a Milok, learned judge want to be
Yes.
Examine more evidence thereafter, even after being satisfied. See, Milok. Salim Ali, 489. Are you satisfied? No. Question number 3. All questions to court. 489, volume 3. Volume 3 means is a judgment volume. In volume, the judgment volume.
Hmm.
Hmm?
Yes.
And similar, the manner in which questions are being put. You appear in the selection test? Yes. Yes. 3. Did you appear in the interview? Yes, madam. Appeared in the interview? Yes. Then, do you know what is an aptitude test? According to me, an aptitude test is how I teach students in a classroom with the help of chalk explaining a subject in a blackboard. That is witness says. Was there an aptitude test? Direct question, answer is no. This is the question. How many persons? 3 persons took interview. What is the gender of those persons living it? Do you know? 9. How many questions were asked? 2 to 3
What is
questions.
this? Huh? What are you doing? Yes, madam, you're speaking on the phone.
And you sit there. Yes.
মোবাইল দিচ্ছিল নাকি?
Yes.
Therefore, Milord, how many questions? 2, 3?
Will you take us through all the questions, Mr. Mitra?
9. Lordship will get bored. No? A question 12. I see the last question. Therefore, naturally, you are not asked to write anything to explain anything. The question, court is leading the witness to give an answer. In advocate had done it, we would have said leading questions.
Yes.
All of them same interview did take place.
Same questions put. Same questions.
And was it a classroom? Then question. Next witness 492. He does not say that no aptitude test. Similar to question 492 page, Mr. MITRA. He did not say there is no aptitude test. write a second, write something, etc.
Yes.
What is asking, what is aptitude test? Then it's same answer given.
We have gone through that, Mr. B.
Doctor gone through that. Very good. Now I'll do proceed. So, my lord, these 7 questions in my response submission was
Mr. Mitra, kindly answer one query. Interview was 5.
interview 5.
Aptitude was 5 marks.
5.
Board of interviewer was the same in respective districts. And where interview and aptitude was held at the same date, same time.
Same time, yes.
So one view was that when interview there is 5 and aptitude there is 5, how are you assessing the candidates? For interview, what is your name? You belong to a family. What does your father do? Maybe these are individual questions can be asked. Now, aptitude, the learned single judge, subject to what you say,
No, my lord.
his lordship wanted to know that actually what questions are put in aptitude.
Yes.
But as there was an amalgamation of 2 traits in one particular sitting, maybe the judge was of the view, maybe the judge was of the view that in the guise of holding a aptitude test, you are giving full marks for that test.
Yes. Some of them full marks. Yes.
This could have been
Yes,
one angle. Now, to that, when there is no segregation from interview and aptitude, suppose I appear in an examination, you put some questions in interview, you give me 2 marks out of 5. Now, for aptitude must be also, Mr. Mitra, you must be putting some specific questions to me.
Yes.
To determine my aptness. How I will determine her? So, in certain examinations, we have seen, subject to be corrected, that the blackboards were there. The person was asked that you make out a figure. What you will teach to a primary student, what you will teach to him. So I think there was the confusion which ultimately the court was of the opinion that there is no specification. 5 there is there, but you have amalgamated everything and you have given 9.5 to a person who in qualification in academic may have got only 4.
Yes.
And by that you have enhanced the marks. I think that would be, we have not yet heard them. So what would be your answer
Yes,
to that,
yes.
Mr.
Oh, bless you. What is not that what questions were you asked? If that would be a relevant thing, but that was not the judge's question. Question was how many questions were asked. I fully appreciate and really grateful to my lord, It would have been very apt to ask these candidates what questions were asked of you regarding your aptitude. That would
These interviewers themselves were not competent. That is where the judge proceeded.
that this proceeding, the interview was not.
The interviewers, the persons who took the interview, they themselves did not know what is interview and what is aptitude.
Yes, that is my next part of evidence. Come to that,
Yes.
I will first dealing with the question interview. Now, my lord wanted to know that what is aptitude test or etc. And what is
that the judge has called for a report from.
Kindly Miller see Rule 2, Sub-Rule C of the Recruitment Rules, Volume 1, page 112. Zero.
Paper book unamended rules are there. Amended. Both you see is same, but other portion.
2C.
You are showing us 112.
Rule 2C. What is aptitude test is defined in the rule.
Yes, it is defined.
So, that question, court should not have asked any witness. What is aptitude? Do you ask all the witness? What is aptitude? Do you know? That was not the question to be asked. Please will not come to definition. Rule 2C.
Yes.
Aptitude test means a test to assess natural teaching ability of a candidate. The court has to go by this. Why ask the questions to all the witnesses? Do you know what is aptitude test? And question it, how many questions? 2 or 3, sometimes 3 or 4, things like that. They will not, I agree that there are a lot of things to be said on the part of the board, on the part of the judge also, a lot of things. You have to weigh this. I am not saying that I have a foolproof case. I have not yet come across any foolproof case in my 64 years of career. A whole case has some weakness, some good point, bad points. It is as it is not a matter between Ramakrishna Paramahansa Dev versus Swami Vivekananda. So there will be some weak points and bad points. You have to weigh the balance. Only question, more important question, Your Lordship, is did the judge made a correct approach? If am I wrong, Lord? Similar, therefore, it's a wrong approach to ask any of the candidates, what do you know what is meant by aptitude test?
Yes.
Now, the selection process, the system of marking was not challenged in the REET petition.
That was not challenged.
Although petition has been filed 5 years after selection been made.
That too without making you parties.
Yes. So, this, let us go by selection process, right or wrong. It's absolutely fundamentally wrong. There are 50 marks in total. 50 marks in total. Out of that,
yes.
50 in total, out of breakup is 40 marks are to be given arithmetically by arithmetical calculation. What marks you obtain in that examination, written examination, BA or thing. Breakup to 0.
That is there in the
rules. 15 that. Though that was 40 marks will be given by arithmetical calculation. No question of any scope of arbitrariness or personal whims. 10 marks only out of 50 left for interview and personality test, aptitude test. And question to be asked to find out what is the teaching ability. Yes. Now, please, now see the one thing from the we will go by the record simply.
Yes, Mr.
I will go by. There is no recording that cross-examination declined.
Yes, that is.
You go by the records.
There is an observation that no one sought for cross-examination in the judgment.
That's in the judgment.
In the judgment, the judge said.
Judgment. But I am saying normally.
Yes, all right. No cross-examination.
Decline, etc. They are not recorded.
No, it was recorded that
there is nothing to see from the records that
no question was asked by the appearing parties to the above interviewers.
Yes.
6th of February order.
6th. No question. The court has recorded that. Now, so now come to a very grave case, important case, important aspect. The board can answer.
George's predisposition to the
Yes. Order record that some on order the board did not pray for cross examination. Board is to answer, not for me. Anyway. But one fact remains as a very grave fact. The persons who will be affected by the evidence very directly, namely persons who had been successful and got their job for the last 5 years, they were not given any opportunity to cross-examine. They had no opportunity to cross-examine, no notice was given to them. So now the question arises for before Lordship, which I humbly place for my Lord's kind consideration. What's the value of a cross-examination? Value of an examination chief done by the judge of remedy, which is not subject to cross-examination by persons affected. Isn't it? Cross-examination in humble submission is part of natural justice. It is not statutory law. Cross-examination. That if the cross-examination and order was confined to against board officers, I wouldn't mind. But on the basis of this finding, court has upset. Now, with our humble submission, there are humble judgments of different courts. What is cross-examination? It's a part of natural justice. And evidence without cross-examination by the parties to be affected cannot be relied upon by court. So my submission would be not only these interviewers, these petitioners who were cross-examined, could not be relied upon by the court for annulling the employment of the non-parties.
Yes, we got you. Got you.
Got you. Milord. Judgment দাও দেখো কোনটা লিস্ট আছে হ্যাঁ কি এত কম্পাইলেশন এত জাজমেন্ট
Mr. Mitro, we were requesting you if you can conclude your arguments
Yes,
on
then
the
judgment.
remaining part.
Absolutely.
Then
I respectfully agree, Milord. That will be very convenient. Chain of thought is not lost. So there are judgments.
Well, it's violation of natural
For
justice.
two propositions, the cross-examination is part of natural justice. So not evidence taken on record without giving the party affected to be cross-examined is a nullity. Therefore, on the basis of that evidence, no conclusion, no judgment, no order can be passed by a court of law against parties affected, namely annulment of that evidence. This will be a provision of law. This will apply both to the cross-examination of the interviewers later on, and also some of the writ petitioners. It applied to oral evidence of both interviewers and writ petitioners. That's because they are being relied upon by the court for annulling our employment. Now, for interviewers, there's additional ground. The court thought he had power under 165 to call for examination of interviewers. There, my lord, I respect to join issue that under 165 Evidence Act, it does not empower the court to call as witness interviewers who are not parties to the proceeding. Section 165 means judgments of gallows, some judgments cited. As a place only section 165 of Evidence Act. See, my lord, what the section says. The-
Interviewers, not parties, cannot be questioned. তাই তো বললো।
Evidence Act also ঠিক আছে তো?
Yes.
Interviewers did not appear as witness before the court. Did not appear as a witness to the court, before the court. 165, can you see me not? Hmm. (165). The judge may. My lord, got it? The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question. Lordship may ask me in the order leading to the cross-examination evidence taken, is it recording in the judge's order which I placed before Lordship that this examination is necessary to discover or obtain proper proof of relevant facts? That is, aptitude test taken or not was relevant fact in this case, and to ascertain that it is necessary whether aptitude test absence or not presence could be relevant fact in the absence of pleading by both sides. Those questions have to be considered by the court. 165 power is not issued easily, ordinarily. So aptitude test, first of all, court has to hold it is a relevant fact, which in my humble submission could not consider to be relevant fact in the absence of amendment of the writ petition. What is relevant fact? A fact which is asserted and which is disputed. That is the controversy. At least fact asserted should be relevant fact. Which I humbly submit, my lord, it is a case of petition. Matter will be decided on petition and affidavits. A petition is different, it's not a pleading. Petition is different from plaint. And I shall cite judgment to show me, judgment Supreme Court said so. In the plaint, you need not plead evidence. But in the petition, you must plead the evidence. That's the difference between plaint and petition. Evidence support of what you're saying, because matter was decided on affidavits. There's also this, I shall cite one at a time, just one line. Now, without deciding that aptitude test was a relevant fact, court had no jurisdiction to invoke 165. Second ground why he could not invoke. And whom he can ask any question under 165. A person who has come as a witness, he can ask, judge can ask. Any witness or of the parties, So the writ petitioners could have been called, being parties, for giving evidence, but not the interviewers. They are not parties. He can call any witness or any parties to the proceeding under 165. Similar. Any fact relevant, and may order the production of document, etc. Whom a judge can call for evidence under 165, judge's power, discretionary power. Judge may, judge may, in order to discover or to obtain proper proof of relevant fact, discover or proper relevant facts, ask any question he pleases in any form, at any time, of any witness or of the parties about any fact, etc. So, my lord, my second ground, humble submission, second point is, in case of evidence of interviewers, court had no jurisdiction under 165 to examine them or call them as witnesses, call them to give evidence. Now, my lord, is evidence another ground, my lord, to place humbly before your lordship, why this evidence taken by learned judge should not be considered to be appropriate by the Honorable Appellate Court. See, my lord, who are interviewed? I have shown your lordship writ petitioners, 7 selected on a discriminatory basis. Now see on what basis? The out of 20 districts, only 4 districts were chosen for examination of interviewers. Please see that's own finding, on the judgment.
Out of 1,000 interviews.
610 judgment starts. Relevant part I'm coming to. See, my lord, the next part. Please, my lord was reading paragraph 9. Best, my lord. Now, my lord, then page 615. My lord, the real question was whether aptitude test of the candidate was taken or not from the table. This question not taken, who raised petition? Page 614 it starts at page 615. 614 his judgment is set out. His order, his own order is set out. First order on 6/2/23, evidence of following named teachers, order the work 6/2/23. Similar interviewers will be examined. That was passed by different order. That is 6 February 2023. Kindly look at that order, my lord, at page 427 of volume 2. Volume 2 of the paper. Sorry, my lord, after shuffling so many. Yes, very. Volume 2, Dr. Kindly go back to. হাতে ব্যথা আমার তো আর সন্দেহ ঠিক আছে রে 427, my lord. 427. 6 February 23. These are order referred to in the court. Can you not come to 427, my lord? Today, my lord, both of you also got this, my lord. Volume 2, page 427. This is the order referred to in the judgment. Today, the affidavit of West Bengal Board has been explaining what is aptitude test has been filed. I do not see what board had to file an affidavit for explaining aptitude test when it is defined in the rules. I do not know what the board was asked. Anyway, and the same is kept on record. Then your board is going to explain. The letters issued by the board to different experts as to the aptitude test were in the seal cover, which has been opened in court, and those letters are kept inside again after perusal of the same by the court, and that envelope should be sealed again. Experts were consulted by the board, apparently appears on the order, for saying what is in the matter of aptitude test. That's apparently happened order. Then 3. Another sealed envelope containing list of persons who took interview of different districts. Different districts, namely these names are given, have been produced. All this similar to what the aptitude test have been, the court asked for, and court gave the list of interviewers for 20 districts are there total. Kept inside, etc. Out of these interviewers, the envelopes in respect of district of Hooghly, Howrah, Uttar Dinajpur, Cooch Behar, and Murshidabad. How many? 1, 2, 3, 4, and 5 have been opened. No, 5 envelopes are opened. Here, my lord may note that no interviewers from Howrah was examined. So, interviewers of Hooghly, Uttar Dinajpur, Cooch Behar, and Murshidabad. Court decided to open only 5 envelopes relating to 5 districts out of 20. And after opening 5, court decided to examine interviewers of 4 districts out of 20. The other small envelopes in respect to other districts have not been opened. and they are kept. They are kept. New spelling, very interesting spelling. And they are also need the spelling.
Yes.
And the spelling of they are also seen that very interesting spelling. They are spelled. they are kept in a big envelope, and big envelope sealed again. Out of the interviewers of the following
It's a mistake of the stenographer, Mr.
That's right. Absolutely. It's stenographer's note. Absolutely.
You should have mentioned that in the bracket, Mr.
Yes. Out of the interviewers of the following district, Hooghly, Howrah, Uttar Pradesh, etc., I need to know some facts about the interview and aptitude test, and whom I call for appearing before this court on 21st February at 2 p.m. and the expenses for the journey paid by the board. Court decides upon selecting again out of 20. On what basis court selects 5 districts only is not disclosed in the order. Order has to be reasoned. Order has to be reasons. I would humbly submit, we will expect reasons given by the judge for selecting 5 districts out of 20. Otherwise, Miller order become discriminatory. Yes. And they explain the board by board and do not act. Then Miller paragraph 6. Amount, how much amount you pay, forget about it. Come to paragraph 6. I do not call all of the persons named in the list. For the district Hooghly, I call person named in serial order. Serial order, that 8 out of 10. That's if serial number 2 is omitted, 4 is omitted, 6 is omitted, 8 is omitted, 10 is omitted, 12, 13 omitted, 15 omitted, 17 omitted. Sorry, omitted. 19 also omitted. For the district Uttar Pradesh, same thing, Milord. Sorry, Dinajpur, same thing. 12 called. 8 called out of 12. For the district Kuch Bihar, still 5 to 14 called. For district of Murshidabad, I call interviewers from interview board. Number is given, namely 6 called out of total. 6 called for examination, out of 9 at least. Serial number 9 at least. So, my lord, this is the basis of the. So, my lord, first, without pay to my humble submission, the court has no jurisdiction to call the interviewers because they are not parties. Then, the process, justice-making process is being vitiated. Process for dispensing justice is being vitiated. Out of 20 districts, court selects ultimately 4 districts interviewers.
Mr. Mitra, we are waiting for your reply to the paragraphs 18 to 22. 18 to 22.
22.
Your reply to this, because these have all been argued.
Of the judgment, yes, ma'am.
Of the judgment, not the,
yes, my lord.
If you can apprise us on the issue of corruption which the court has referred. Because there had been, according to the judge, there had been a scam. There had been employment in lieu of money. Whatever may be the intricacies, we are not.
Yes.
We are wanting from you the reply that why this thing which has affected. It seems that the court proceeded that as there had been a scam in the entire education process.
Yes,
Why should I not hesitate? Why should I hesitate while passing an order of appointment cancellation of 30,000?
Good.
Bread and butter is involved. These persons have already worked, as you said, from 2017. We are in 2025. They are wanting today that you take away their jobs. You cancel their appointment. Why? We have not yet heard them. Maybe they will be laying much stress upon this issue of corruption which has been said by the judge. And on the basis of which the judge has said that niceties need not be gone into. These persons are illegal entrants. I will throw them out. Mr. Mitra, please explain to us that
But
what
that
is.
is, I am humbly trying to show there is no basis.
No, that we understood. You have argued. If you can summarize your argument.
Yes.
Apart from what you have adopted from them, today you have enlightened us on the issue that please read the orders of 17 January and 6th of February, which has led to summoning of these interviews and everybody. You have pointed out the infirmities.
Yes.
Application of 165 we have pointed out. Now, you can argue, Mr. Mitra, we cannot.
No.
We will not stop you.
No, please stop me without when I talk irrelevant matters.
No.
Please stop me without.
Mr. Mitra, you are such a senior.
I hope the
counsel. We
situation
also
will not
learn
arise. But
counsels.
if
We
I
also
at all.
learn. We want your argument on the issue of these paragraphs 18 to 22 where the court has proceeded.
Totally. Yes, Milord. If
you can apprise us on this, I think
yes.
If anything left out, I can hear them and then we can call you again.
I've decided to submit what is scam. Yes. And
what
whether
is the linkage?
Judgment.
Because the judge.
Yes. Court scam on which side?
Right.
Yes. Then all this can be humbly submitted. But what's the use on the ground of scam? Who is guilty of scam? Board. Board is guilty of scam. And what justice you are rendering? Throwing back all of them back to the same old. You are referring back to the persons to the same board which you feel corrupt. Is it interest of justice? Or do you encourage corruption by this order? You find an institution is corrupt. and the same institution being asked to go through the selection process. What's the use of calling it justice? Kindly consider this, my lord. I'm saying with great grievance, with great sorrow and aptitude.
So why you are sending it back to a
If
corrupt body?
Yes, if it's scam, this order will create another scam. Another series of petition filed for challenging the appointment. Back to square one as we normally do.
So according to you, then it ought to have been sent to whom? If it is court arrives at a finding that this board is a corrupt institution, then the judge ought to have said that, according to you, that we
Some
will
other
appear.
institute will take the examination.
Mm-hmm.
Some other body will take the examinations, selection process, who are not found to be corrupt by the learned judge.
That is your submission?
Yes.
That it should be sent to...
And not having done so, what is wrong? Look,
Yes.
what the similar to what? Justice has been scored. A person, an institution found to be corrupt, scam and all that, same body is being asked to re-examine them. What's the point in doing justice here? If you don't have the power to remove that institution, then why take all this trouble?
But still the persons will be in problem.
If the court has no power
No,
to remove the institution.
Suppose it is not sent back to a board. It is sent back to an independent body. But still you will suffer your loss of appointment at
That
this
is not
juncture.
different. That is different thing. Still, the new body may also be corrupt.
Yes.
Now, my lords, with total disgust and disappointment, say, my lord, that through evolution during the last 60 years, what is corrupt, what is not, has now a dividing line is being obliterated. Yes. So, my lord, we have to do justice under present circumstances. When you don't have the power to change the examining body, and you have to go back to the same examining body, then how far eager the court should be to set aside the appointment given by them. This is a question I'm humbly pressing your lordship. This is the disappointment on my part. 20 years back, did you find case of scam and all these things? But media trial and all. Anyway, my lord, I shall go by law. I'll raise a proposition humbly. If the court has no power to change the examining body, then why? But
it doesn't have the power to?
Court has no power. Nobody has said court can change. In fact, I think they will show judgment that examining body board cannot be replaced. Anyway, they will show the judgment most probably, if I argue that. That is different thing. But I'm asking a lordship to look at it from a different angle from this matter, which has not been considered so far. What's the utility? Will the justice be served by annulling this employment and asking these people to undergo a fresh selection process in the hands of the same person? This is then we shall deal with the question.
Done.
But, please don't.
No, we want to
Yes.
know. It appears that we see that there is corruption.
Yes.
Money is being taken, jobs are being sold, but we will keep silent. Why? Because we cannot send it back to
Because
the
not
board.
there is a judgment to the effect that court cannot change the examining body.
In spite of corruption, scam, everybody will be a silent spectator then.
Against statute, it should not be silent. That is the point, my lord.
Yes,
Therefore,
yes.
Therefore, my lord, in my humble opinion, court will be very cautious
Yes, that is all
to
right. Cautious.
annul decision taken by a statutory body. Court will not act as a court of appeal. These are settled proposition of law. Do the court find the selection process is valid as framed by the rules? Nobody challenging that. While following the selection process, has the board done something so arbitrary, so capricious, as no reasonable person could do? Then you call it a board is at fault. That is the Mullah paragraph 16 to 19. When I deal with that question arises, my lord. That, my lord, I'm grateful for opening up. And that is the point. My lord hit the bullseye. Is the ground for interference made out by the judgment? In the judgment.
Pardon?
Is the ground for interference with the order of board has been made out by the judgment. That's why taking the grounds taken one by one and trying to show each of the ground is not sustainable in facts or in law. I'm trying to, my lordship, I'll put my case, lordship, pressure would be to consider it, and if not apt, to reject it. That was my lord's pressure. But let me have the pressure of putting my client's grievance, and very justified grievance, that are you working in a job on a post for the last 5 years? Suddenly
we understand that they will tell it before. Yes. But this question, what is your answer to this?
I'll
Mr.
give the answer
Mr.
because
Mitra?
much more thought on the next day.
You are a very senior counsel. You say that.
No, actually, this has.
No, we want to know
Correct,
that
but-
if suppose you are in the seat of an arbiter, you see that there is rampant corruption. Ministers,
yes,
persons engaged in administration, everybody is doing what is not expected of them. There had been interference of court on repeated occasions. So today, even after appreciating that, yes, this is a society where there are,
correct.
then
But
court
may-
will not do anything.
Today, good afternoon. One principle is court does not pass any infractuous order. Settle law. Will this be an infractuous order? Number one. Number two, is there grounds made out in the judgment to say there is rampant corruption, rampant violation of rules of selection process? That is the
CBI
point
is
I'm
in
making.
ceasing of such investigation.
Yes.
CBI is in ceasing of such investigation.
No, that is, but judgment, I shall come up to aptitude is a ground. I'll show that it could not be a ground. Other grounds.
We expect an answer
deal with
from
that.
you on this issue, Mr. Mitra, as you have made the submission that court cannot send it back upon finding that this board is responsible. Court cannot send it back to the same person for a fresh selection process. In the backdrop of the other issues which you have argued, that you are taking away my bread and butter after 5 years. You are the state, you are the almighty. So then you said that don't touch a process even if you find it is a corrupt process.
No, I said,
we may be
I have
wrong.
submitting, there is no, you cannot, the judge could not find that there is a corruption. I'm dealing with that ground one by one. Each and every ground will take. I said, judgment has not made out a sustainable ground for holding corruption.
No, Mr.
That is the
Mitra,
submission
you have taken us up to paragraph 10.
10.
The only issue we want to hear from you is the paragraph 21 says,
21, yes.
in such circumstances,
In,
36,000
yes,
cancelled.
in what circumstances?
Right, right. You may say so. But this is preceded by a statements in paragraphs 18 and 19.
18. Now, the question is, what is stated in paragraph 18 and 19?
Yes, you satisfy.
Are they, yes, are they sustainable? Have they been proved? Have they been, any case been made out by the judge in this order? What is said in 18, 19, that is the point.
Huh?
Now, similar deal with that. What court has said?
No, Mr. Dotto argued that what is corruption? He was arguing on the first date that how can the court say there is corruption?
No, court can say but in this case, corruption is not proved. That is what I shall show you. I analyze paragraph 18 and 19, which I've done up to 18. I've done it. I'll try to show.
We will hear you now. We will hear you on 18 and 19. Mr. Mitra, you have finished the others. Anything left, we will call you.
Yes.
18 and 19, you satisfy us on.
শুনতে চাইছেন আমি করতে শোনাবো May I only deal with paragraph 18 and 19? I have to deal with paragraph 18, 19.
No, we cannot stop you, Mr. Mitro. You want us to take us to any other paragraph. We will only ask you that if you can shorten this and give this answer.
Yes.
We are
So if you want to continue now, it is after 4:30.
No, we do not want to punish you.
Then, if your lordship think I may be allowed to speak for a few minutes more, then give me a next date.
Yeah, we have allowed you for the entire afternoon, Mr. Mitro.
Yes, lordship, and very kind of you, my lord. My lord, I am obliged to the court who allows counsel to argue.
Tomorrow 2 p.m.
Tomorrow.
Tomorrow 2 p.m.
Tomorrow 2 p.m.
You please finish your argument on that so that we can take.
কেন জজ চাইছে শেষ করতে আমাকে
কালকে আছে
জজ আমাকে শেষ করতে চাইছে এদের কি আছে বলতে দেখো না
মাথা খারাপ হয়ে গেছে
যত ডেটটা দিক ভাই আমি বেরোই তারপর তোমরা বলো এখন এই নিয়ে আবার চলবে আর্গুমেন্ট
বলছো তাহলে
Very good. At the same 2 p.m.
And how long will you take, Mr. Mitra? Within an hour you do it. Please do it within an hour.
And that I shall not take more than what I should take. I agree with you. And lordship tell me how long should I take? I will finish within that time. And leave it to me, ask me. I shall not take more than what is necessary.
No, what is your wish, Mr. Mitra? How much time you are?
Should not be beyond 1 hour. Within 1 hour. Should not be. But I have a team of juniors who are very, very knowledgeable.
No, they are forcing you. Make more submission, make more submission. We have heard Mr. Mitra and senior.
May I take my desk and leave now?
Day after tomorrow at 2 p.m.
Tomorrow, day after tomorrow, 2 p.m. Doctor. Oh, bless you.
Learned senior.
Just keyword.
Compilation and the paragraph numbers.
Sir, আপনি কি অ্যাড করবেন না শোনা যায়
WBC
After Mr. Mitra, senior Mr. Mitra finished which is sufficient. Kindly give me half an hour. I won't take more than.
Done. Say day after tomorrow, 2 p.m.
After he finishes, my lord, I shall subject to my lord the permission of all my learned friends.
No,
Because
you don't need our permission, sir.
Yes,
Definitely.
Give me half an hour. I shall.
Where from you are coming, Mr.
For the prime.
What you are handing?
5 minutes.
What you are
Last occasion, your lordship asked me to application, my lord. All the applications, 74, 78 applications, my lord, I have jotted down and my lord, as comparative chart. My lord, your lordship, my lord, kindly consider the fast page.
For some of the addition of party applications, my lord.
just Mr. Bishas learned it.
My lord, there are 4 addition of party applications taken out by my clients.
Addition as party respondent.
Party respondents, my lord.
Along with
My lord.
with the writ petitioner.
With the, my lord, appeal, main appeal of the board 873. My lord, the difficulty is, my lord.
You are the addition of party as applicants.
Yes, my lord. As
why you have not preferred?
No, as respondent writ petitioners. Why
you are espousing the cause of which
writ petitioners, my lord? Why? Because, my lord, we filed separate writ petitions before the learned single judge. Now, my lord, showing the pendency of the order, my lord, our matters have been adjourned senator. We are not getting our specific cases. My lord, we were participating.
If we hold in your favor,
my lord, I tell you, my lord,
guided by that.
Yes, my lord, I
don't
tell you.
make it more complex, sir.
My lord, only one thing.
Don't make it. Suppose whichever it goes,
yes,
you will be coming within the fold, sir.
No, my lord. Your lordship.
Our judgment will be guiding all the remaining writ petitions all over pending in High Court. Don't worry about that. What is the mobile টা দিয়ে দাও ইয়েস ওই দেখো কে মোবাইল নিয়েছো কার whose mobile is it?
I have deposited. I am taking it.
Give it to Mr.
But I am appearing in item number.
শুনতে পাচ্ছি না কিছু
I am appearing in item number 30. Lord, only give me, Lord, 5 minutes time.
Yes, start. We are 5 minutes here. Please
start. Yes, I can start.
Yes.
Such goodness, sir.
কোন ফাইলটা বলছো দেখো
Lord, item 30.
Mr. Bhattacharya, you are taking 5 minutes and con.
I just only because I was watching the proceedings, I heard what has been said by others. Later, when your lordship is taking up the matter, Milord, on the next day, Milord, do not become Milord. Let there not be a personal animosity by the court upon me.
That is why wise people have said that look at the clock before you make submission.
That's the reason I'm saying. On the next day, kindly give me that time.
No, next day not possible.
Kindly do not give the hearing, Milord. Then, Milord, I will convey that to my clients.